I assume, so maybe we'll move on. Are they right here? Oh, okay, all right, good. All right, well, the next item on the agenda is our series of grievances, first being 2117. I think,
yes, but I think Attorney Bolton, Mayor, will explain the grievance process for the
all right, thank you.
Commissioner's
Attorney
benefit, if
Bolton,
that's okay.
who I've not yet introduced, is here, and he's going to explain the process that we'll use to hear each of the grievances.
As you're probably aware, there's a collective bargaining agreement between the employees of the Division of Public Works and the city. And as required by New Hampshire law, that collective bargaining agreement includes within it a process to resolve disputes. Those disputes are known as grievances, and the procedure is known as the Grievance Procedure. So you're here today as one of the steps in the grievance procedure. Essentially goes that if there's a dispute as to whether the contract has been followed or violated in a certain situation, an employee can first bring it to the attention of his supervisor, and then the employee, with the assistance of the union, can, if they are not satisfied with the immediate resolution in the less formal process, they proceed to step one, which is bring the matter to the attention of the superintendent. The superintendent responds within the time period specified in Article 14 of the contract. It then can be moved up to the further step, which is the Director of Public Works, and the Director of Public Works renders a decision. And if the union and the employee are still not satisfied, then they can, within the time specified, bring it for a hearing before the Board of Public Works. These time limits can be waived by the agreement of both sides, and in many cases they are. Sometimes there's a dispute as to whether they have been waived or not have been waived, and you may have occasion to apply that requirement as well. So you will hear the union's position, you will hear the management's position, and ultimately you can ask questions, you can try and determine the facts as you need them to determine whether the union is correct, that some provision in the contract has been violated, or whether management is correct and they've properly applied the contract to the situation. And there are a number of them. I believe there are 7 of them you will hear. That is essentially your role in the grievance procedure. From here, if the union is not satisfied with the decision as you render it, they have a right to proceed to binding arbitration on the matter. So an arbitrator is selected, and each side presents their case to the arbitrator according to, again, according to what is provided in the contract, and then the arbitrator makes a binding decision. So you're the next to last step in the entire grievance procedure process.
Does anybody have any questions of Attorney Bolton? I do have one. So the issue in each grievance is whether the contract, written contract, the collective bargaining agreement has been violated or not?
Correct.
Okay. All right, well, let's go on to,
I think Commissioner Shea has-
Commissioner Shea.
And so would we have kind of follow a motion process if we were to have an alternate solution? Is that how we would come to a decision here if it's different from management?
Yes, you could say, well, management was wrong in how they did what they did, the correct thing would be X, and X might not be exactly what the union thinks the correct thing to do would be. So you could have a third alternative, perhaps, and if that's how you vote, that's how you vote, and if the union's dissatisfied with that, they have arbitration to resort to.
And would they inform us today if they're satisfied, or would they go and discuss further and come to some determination at a later time?
I think in most cases, they will come to a determination at a later time. They have a time limit by which they have to request arbitration, but it's somewhat extended. It's not a day or two. I think it's like 90 days, yeah. Yeah, 90 days, so they have quite some time, and they may utilize some or all of that to consider what their course of action will be.
Thank you.
Anyone else? All right, well, we'll go to the first grievance, which is number 2117. So we will get a presentation from the union and then hear from the department.
Mr. Chairman, if I may,
You go ahead.
I'm Bobby Jones. I work for AFSCME Council 93, the exclusive representative. The union had put forth a list of grievances, one of which included 21-7, where the grievant was Vern Thompson regarding a suspension, and the union was notified late this afternoon that that grievance was not being heard today, and we're wondering why that grievance is not being heard since we've submitted it for this step.
So, Mr. Jones, that actually, I have told numerous times that that grievance was not going to be heard because it didn't follow the process within the contract. And I did mention that you should talk to Attorney Bolton about next steps if you wanted to discuss that further. But I don't know if you want to speak to that further, but.
I think it's untimely at this point. The time limits were not followed and were not waived.
So can you point to a provision of the contract that states if the timeframes are not followed, then the grievance is dead? Because during your presentation to the board, you said it would be the board's decision as to whether or not the timeframes were met or they were extended. And I'm not aware within this collective bargaining agreement of such wording, whereas other bargaining
it's there,
agreements
sir.
do have that.
It's in Article 14, and it does specify that the time limits may be extended if both parties agree. You don't have such an agreement.
There's also isn't wording to
I'm
indicate
not
that.
going to argue with you, sir.
Very good. The union protests that this will not be heard, and we'll be moving forward for arbitration with it. Thank you.
All right, so we'll go on to grievance 2117. Just introduce yourself and then go ahead.
Yes. Hi, I'm Alex McLean, AFSCME Local 365 President. We have grievance number 2117. Do you want me to read the grievance as it is written on the first page so that you hear it out loud and then go into our presentation?
Yes, please.
Okay, not a problem. So 2117 is a part of the street department. It is a class action. It's the CBA states, the collective bargaining agreement, that states you receive $1 extra for the hot box as well as $1 extra for using your CDLA. It is the union's stance that historically compensation for a hot box is part of the CBA. Per our current CBA, it was agreed upon to compensate for utilizing your CDLA. We have multiple hot boxes that do not require a CDLA. The union sees the contract as employees need to be compensated for the hot box, as they always have been, and compensated for utilizing a CDLA, as no positions are required to hold a CDLA. It's kind of along the same lines of, you go to Burger King and you order a meal, you get fries with the onion ring. You want the extra, you got to pay for the extra. So that's the union's stance on this.
Any questions for, yes?
Can you elaborate on hot box, what that means?
Yeah, so a hot box is, it's generally towed behind a vehicle. So the DOT rules and regulations, a combined GVW vehicle weight of a truck and trailer, anything over 26,000 pounds requires you to hold a Class A license, a CDL-A license. We have 2 hot boxes that are underneath that weight restriction and 2 that are over. So what's going on is generally it's never been an issue before because we've always been compensated for the hot box. The issue has arisen in the fact that now we are requiring drivers who are only required to have their CDL-B license for the position. We are utilizing drivers that come on board with their A to tow these other trailers, and they're only compensated for the hot box. They're not also compensated for now utilizing their CDL-A.
Commissioner Shea.
So if you're out doing lawn maintenance or something like that, you're not using a CDLA, right?
Nope.
So if you are driving a vehicle that does not require a CDLA, it sounds like you're not using the CDLA. Is that fair to say?
Yes. So on a general day-to-day, you don't use your CDLA.
And you don't get an additional $1 for each hour worked?
Nope. You only get it when you were required to use it.
And so are employees being paid the additional $1 when they drive the hot box that's underweight, and then an additional $2 when they're driving the hot box that's overweight, or they are not when they are driving the one that's overweight requiring the CDLA?
No, they are only compensated the $1 for the hot box. So that is wherein lies the issue.
In both instances?
In both instances, yes. So like if you took out the hot box that doesn't require you to utilize your CDLA, it would just be a CDL-B driver towing that hot box. They would just get the hot box rate. It is now an issue that we have that they have a hot box that requires you to use both. You're required to tow the hot box, but now that hot box also requires you to hold a CDLA.
I just have one more question, if I may.
Go ahead.
So, can you explain kind of elaborate on the circumstances from prior to this issue arising and compensation? Are the new hot boxes the overweight ones, or are the new hot boxes the underweight ones? Were we compensating before for the CDLA or not? I don't fully understand that.
So this falls under the new contract that was signed last year. We added the words, or the words were added to be compensated for using a CDLA. So it reads, I don't have the contract in front of me. Hold on one second. The contract is, I should have brought that up with me.
Page 5.
Thank you very much. So the contract reads, employees who operate the sweeper, drives pulling the hot box, which was originally in this contract prior to this one, or operates a vehicle required by the state or federal law to operate by a CDLA license, and who have met the qualifications prior period specified in paragraph D above will be paid the differential of $1 per hour above the rate of the position, in addition to any shift differential which may operate while operating such equipment. So the piece that was added was the utilizing your CDLA. That has never been in there before, and it is now a new thing.
I have one more, I'm sorry.
Yeah.
Go ahead.
So if somebody, this isn't a real thing, but hypothetically, if someone were driving a street sweeper with the heavy hot box on the back, is it I know it's not a thing,
Yeah.
but is it your feeling that in that instance they should get $3 an hour?
I mean, you're asking them to do 3 different positions. You're asking them now to utilize a license that they don't necessarily need, and to sweep the road as well as the hot box. So, yes,
And just a thought.
it's not an instance that would ever happen.
Right, right. So I struggle a little bit with the word "or," because it seems like those are the three conditions under which someone would receive a differential. It doesn't sound like there is space in that language for each of those three things to be considered on an individual basis. I understand your sentiment on it, but with the use of the word "or," I struggle to see where there should be two differentials. It seems like there is a class of differential, and that if you fall into any of those buckets, then you get $1 an hour. I'd welcome further thoughts on that, but that's my first impression of the issue.
Yeah.
Superintendent Ibarra, would you like to speak to?
Well, can I just ask, does anybody else have a question, though? Commissioner Moriarty?
I do. The grievance itself, is it one employee with this grievance, or is this, like, are we talking about multiple employees who are involved with this grievance?
Yeah, so it only pertains to essentially the truck driver classification. So it was filed as a class action for the truck drivers. So nobody else has ever asked to tow the hot box or any of that except for a truck driver. Other classifications are asked to utilize their CDLA though. So
then all the truck drivers, Mayor, if that's okay if I proceed, all the truck drivers who have pulled the hot box have qualified with, under D, the other requirement of 120 hours within a 24-month period?
yes.
They have so they met that qualification. And so then the only other question would be whether the CDLA is a requirement or not. Is that the
Yes.
gist of it? And you're saying that
Yes, per our PDFs, a CDLA is not required.
And so that would be something that I guess the superintendent or the city attorney may want to elaborate on. Because the way I read this, it doesn't say, and Commissioner Shea, I may disagree with you on this, because the way I read this is that the employee can operate the hot box or have the CDLA. It doesn't say he has to have the CDLA. That's my interpretation, but I don't know. That's just the way I read this. It doesn't say must have the CDLA license. So it says if they operate the hot box and they meet the qualifications of the hours, then they should be okay. So I'd be interested to hear how the city responds to this as well.
Anyone else? All right, Commissioner Schoeneman.
It's my understanding that as you said, some of the hot boxes don't require a CDLA.
Mm-hmm.
So it's the individuals who both pull the hot boxes and have the CDLA that want additional remuneration. And those that pull the hot box that don't require CDLA and they don't have a CDLA, are they also part of this group that's seeking a grievance?
No, so if we were using the hot boxes that didn't require the CDLA, on our stance, this grievance, there isn't a grievance. The grievance is because there are select few, I want to say, I'm pretty sure the street department only has maybe 2 or 3 drivers that come in already with their CDLA, and the way that this is now is when they find out that they have somebody with an A, they just make them, the lowest guy always gets mandated to the hot box. That's generally how it goes. So the lowest person, so sometimes the lowest person might have a B, but if they want that A hot box, it could be 2 or 3 guys above him that get mandated because they have their A. So it is, we are going by that they have to have their CDLA to tow the hot box, but they're only compensated for the hot box. They're not compensated for also utilizing their CDLA, if that makes sense and answers the question the way you were looking. Yes?
Commissioner Lemon.
Thank you. So in this paragraph E, it says, employees who operate the sweeper, they get a dollar differential?
Yes.
Regardless of, okay.
Yes,
So
ma'am.
to me, I'm kind of with Commissioner Moriarty on this, because it says, this condition, a dollar differential, second condition, dollar differential, or who operates a vehicle required by state or federal law to be operated by a CDL license. Those are 3 different groups, right, that get a dollar differential. And what you're saying is that if you have both a CDLA and you're doing the hot box, you should get $2.
Yes, ma'am.
Okay, thank you.
So, before the new contract provision,
Yes.
you got $1 for pulling the hot box.
Yes, sir.
But if you had if you were driving a piece of equipment that required the CDLA, you did not get anything.
There was no such compensation for a CDLA prior to this new contract, no.
And can you give an example of a piece of equipment that requires a CDLA that an operator would have operated under the old contract that would not have been compensated?
Towing any trailer that is over, that with a combined GVW weight of 26,000 pounds. So the tractor trailer, we have a low bed to move a piece of equipment, that gets compensated $1 now. That was never compensated $1 before. So basically, at any point, if anyone's towing a piece of equipment to or from a job site, they get compensated $1 or compensated $1 for any trailer combination that is over 26,000 that requires your CDLA.
So what the language accomplished was to make sure that someone who was driving a vehicle, not a hot box, that required a CDLA would now be compensated $1.
Yes.
But the provision does not say that if you're doing 2 of these things, you get $2.
It does not.
Anybody else have questions? All right, management, or I don't know, Mr. Ibarra?
Thank you, Mr. Mayor. Commissioners, good afternoon. Attorney Bolton. John Ibarra, Superintendent, Street Department. So as Alex alluded to, this all occurred during our last contract negotiations. There were changes within the contract. The CDLA was a requirement, as an example. To run a sidewalk tractor was an operator job. Well, we eliminated that as an incentive, needing more bodies to get in those tractors to clear the sidewalks during the winter. Anybody with a Class B is now able to get trained and run that machine. So that opens that overtime up to anybody within the division. Started as an incentive in that aspect, so it affected the snow program. And then it went into the hot box as an incentive to get guys to take that. We do have a percentage of guys on the department and through the division that do hold a CDLA, excuse me. And as an incentive to get them in there, this language is incorporated to the change in the contract. So I'll read it one more time, because I'm also hung on that word "or," and that's my interpretation. I share that with you folks. Employees who operate the sweeper, drives pulling the hot box, or operates a vehicle required by state or federal law to be operated by a CDLA license, and who have met the qualification period specified in paragraph D above, will be paid a differential of $1 per hour above the rate of the position, in addition to any shift differential which may be appropriate while operating such equipment. The shift differential would be the sweepers. They come in at 345, so there's a shift differential there. So they're the only ones that get an addition to that dollar an hour. Everybody else is just for utilizing their Class A. If they're going to pull anything, actually, it's a combination vehicle of anything over 10,000 pounds. So that could be even an F-350 pulling a 10,000-pound gross load or greater. All right, so that's where that comes in. And really, that's all I have as far as a comment to that, and I'd ask Attorney Bolton if he had anything he'd want to add to that.
I think you've covered it.
Okay?
Does anybody have questions for Mr. Ibarra? Commissioner Shoneman?
I don't know if this is specifically for Mr. Ibarra, but what is the grievance seeking? Or what would be the result of the class action if it's approved versus denied?
My interpretation would be they're looking for $2 an hour, one for utilizing a license and one for pulling a hot box.
From now on, or back pay?
Well, if you awarded that,
Retroactive.
that would be back pay and from moving forward.
I see. Okay, thank you.
How much
Commissioner
does it
Lemon.
cost to get a CDL license? CDL?
Well, the rules just changed. I'm not exactly certain, but I heard a number around 3,800. It's run through the state now.
Okay.
It used to be you could gain employment and train under somebody that had that Class A license that was 25 years old or greater, like I did back in the day. And you get your permit, you ride with them, and you go get a road test. Now there's more stringent requirements through the state, and they have attached some revenue generation through it.
So if somebody comes here and they already have a CDLA license, they have a leg up,
Sure.
okay? But if you're working here and you want to get your CDLA, does the city help with that, or are you on your own, or how does that work?
Glad you asked. In the past, we have, but now with the new rules and regulations, we're seeking ways to get that done. The city has made arrangements. We've put on a couple guys without a CDL license. We're going to get them their CDL license. I believe that's running through risk. But there's stuff that I'm not aware of
But
as far as those regulations.
Just the distinction between a CDLB and a CDLA. So we're working with them to get the CDLBs.
Yeah.
Correct.
Commissioner Shea?
When someone is hired or when they receive their CDLA, in terms of like the pay grade, is there a difference there at a base rate for an employee who has their CDLA?
No, they're all hired at the same rate as a driver. That would be an incentive. So it's called out in the morning as a seniority. All right, we go out on the floor and we say, who would like to pull a trailer or a hot box today? If they all decline, then we would, by contract, mandate the bottom guy into it, the lowest CDLA holder.
Thank you.
During the negotiations, I assume this provision, that the additional language for this Article 7E was discussed with AFSCME?
That's correct. They signed off on it.
During the negotiations, did anyone from AFSCME suggest that this would mean that an employee would be double paid for CDLA license plus the hot box?
I was actually part of the negotiation team, and that was not the intent at the time. And I heard no objections at the time myself.
Thank you. Anyone else? Commissioner Moriarty?
Yep. I mean, my thoughts on this whole process is that if the city's in the wrong, I have no problem going in favor of the grievance, but I don't see where the city is in violation when I read 7E. It seems like they follow the contract. So the wording may not be what the union would like to see, but then the wording has to be changed. But as I read this, I don't see any violation. That's my opinion.
All right, well, I think, does anybody have any other questions, either of the union or of management? Is there a motion regarding the disposition of grievance 2117? Commissioner Moriarty?
I would move to deny the grievance.
Thank you.
Any discussion? Commissioner Shoneman?
Obviously, the reason we're discussing this is because the wording is confusing. The wording is not clear. There are several interpretations floating around of what that "or" signifies. I think if we deny this grievance, we definitely need to look into going back over the language and stating very clearly this, yes, it means you can be paid for each stipulation, or no, there's no cumulative effect of having these three conditions. And I think that to prevent further issues will have to be redressed right away, I would think.
Well, I mean, in reality, the language doesn't get changed except in the context of the negotiation of a new collective bargaining agreement. That's generally how things go.
So is this
You'd have to
grievance going to
reopen
come
and
up
go.
again?
Pardon?
So is this grievance going to come up again until the next collective bargaining?
Well, the Attorney Bolton can correct me if I'm wrong, but this could go to arbitration, and then the arbitrator decides one way or the other. Should were the board to deny the grievance, the arbitrator would decide in a binding fashion what the contract means.
So the city's intention when they made this, this paragraph E was to pay for one of the three, $1 extra for one of those three, not cumulatively. And that was the city's intention, and the union signed off on that. And that's what everyone is in agreement here. And so that's going to be the language going forward and the result of this discussion, that's what it means. That there's no double paying, that this is for one. or the
Unless
other.
an arbitrator were to rule otherwise.
Okay.
All right, motion, you've heard the motion. Is there any other discussion? All those in favor of the motion say, the motion that the grievance be denied, all those in favor of the motion say aye.
Aye.
Opposed? Motion passes and grievance 2117 is denied. Now we're going to go to grievance 2152.
$21.52. This is for Solid Waste Department. Solid Waste Department kept summer help beyond October 31st to perform work that full-time employees signed up for. According to Article 2 of the collective bargaining agreement, management posted a temporary assignment for the soft yard waste season, identifying a need for help with the soft yard waste. Solid waste season within the solid waste department that runs from November to the first Friday in December. Volunteer sign-up sheets were posted division-wide in which AFSCME employees signed up for. There were a number of employees that were denied the opportunity to be a part of the yard waste season. By denying these employees the temporary position, management backfilled the positions with summer help in violation of Article 2, which states, "No summer help will remain employed beyond the end of October and through the first Friday in December, except to fill remaining unfilled temporary work assignments for soft yard waste."
Anybody have questions?
Commissioner Shea.
Do we have some manner of record of the employees that have signed up and were declined the opportunity to do the work?
I do not have that on me, no. But there should be an archived record of who signed up for the soft yard waste season, yes. I do believe management keeps that on file.
Thank you.
Commissioner Shea?
And so, can you elaborate on what you are seeking to make all monies whole?
So I believe most of the employees that would have been denied the opportunity to go over to the solid waste department, they work at a lesser rate than the CEO rate, the collections equipment operator. Generally, it's at the time of this, I'm not sure what the rate was. We would have to go back and look. It's generally like $1.50 more is what it's, depending on the truck driver position. I believe it was mostly truck drivers that were denied.
Well, so the summer help doesn't drive the trucks, do they? Do they? No.
No, but it is the position of a collections equipment operator to not only pick the trash, but also drive the truck.
Now, there may be other ways of doing it, but as I recall seeing it, there's somebody driving the truck and there's someone riding on the back who gets off and then, picks up the barrel of soft yard waste and puts it in the back of the truck.
Yes.
And is it usually a 2 or a 3-man crew who does this?
2.
And you're saying that, what, a truck driver asked to be on the back of one of the trucks, or?
No, so they post the temporary job assignment because we get inundated with soft yard waste through the month of November. So they sent us set a sign-up sheet, and there are quite a number of us that volunteer to go over there to actually ride on the back of the truck and pick the soft yard waste, yes.
And at what rate are you saying you would have been paid? At the truck driver rate?
No, so a lot of these guys are already the 120 hours minimally qualified for the rate of pay, and I can look right back here and tell you what the difference is for the two. It's a truck driver makes truck driver right now makes $24.87, and a collections equipment operator makes $25.70, so almost a full $1 more.
Even though the truck driver, I don't quite get it, but
The truck driver not only drives the truck, but also picks the soft yard waste.
I thought the guy in the back of the truck did that.
Yes, yeah.
You're saying they both get off the
we-
truck?
You switch off duties with the other person. Like if it was myself and Matt Davidson, Matt would drive for a little while, I would pick, and then we would swap, and I would drive for a little while.
And does
he
the
would pick.
summer help, are they allowed to drive the truck?
No.
So when you've got the summer help on there, the truck driver always drives the truck?
Not generally, no. I myself, when I'm over there, I get out and help my summer help.
And then you'd get back in and drive?
Yes.
Commissioner Shea?
Was there any reason given to these employees that they were not selected for shifts that they signed up for?
Their management's reason is written in the responses.
And so are the employees, sorry, I've just.
Yeah, go ahead.
And so are the employees who have filed this grievance, were they otherwise assigned? And so they weren't denied hours, they were denied this particular task in the differential? Is that correct?
Yes, as well as overtime. So this was filed as a class action. This is for, this is and has always been the way that we have done this. It has gone to a temporary sign-up sheet, and those wanting to go were to go. And then it fills that department and helps alleviate the yard waste season. And with the new wording in the contract again is it was added that that summer help would not stay unless for the whole backfill. And so before, summer help had a cutoff date of November 1st, and then they were gone. And then we came over to help, and now it was put in there that they could stay as long as everybody else was given the opportunity, and we had employees that were not allowed to go. So that's why this grievance is here today. If that makes sense.
Commissioner Schoeneman.
Could you explain the city's response to this grievance?
I can step down.
Well, could we finish with Mr. McLean, if anybody has questions for him, and then we'll go to the city?
Yes.
Commissioner Moriarty.
Right. Once again, I'm trying to interpret, as you all are, the contract, right? And so your grievance says they're not supposed to work beyond October 31st, but yet the contract says the first Friday in December they're allowed to work till.
Yeah, if you continue to read that section, it states that only to otherwise fill the positions as needed. So no summer help will remain employed beyond the end of October through the first Friday in December, except to fill remaining unfilled temporary work assignment for soft yard waste. So they kept summer help all the way through to December and denied employees the opportunity to go over there.
I mean, again, I'm trying to interpret what exactly that means. It doesn't seem like, did they work beyond the first Friday in December? The temps?
No.
Okay, so there was no violation there as far as time?
As far as,
The time when they stopped working. They didn't work beyond the first Friday in December.
they did not work beyond that.
Okay, so that's not a violation. You're just saying it wasn't right for the temps to stay on and do that work?
It is, they could stay on, but how can they stay on if they were there to fill an opportunity that was denied to X amount of guys? Let's say it was eight guys. There was 8 more guys that could have been utilized to the point where, yeah, you could have then kept summer help. But by denying those guys, how can you keep summer help? Because it clearly states that summer help is only to stay to fill the unfilled work
Temporary
assignments.
work assignments, and then the city said that they put up a list for you folks to sign.
Yes.
And so if you didn't sign, then they had to fill it. But you're saying that didn't happen.
No, we signed the list. There was a whole list of guys. Let's say there was 10 of them, okay, for the sake of this. 8 were allowed to go, 2 were not, and they continued to keep summer help. So therein lies the violation of the contract, because they're showing a need for more than what they actually took off of the work assignment list. Make sense?
So did any of the summer help do anything other than pick up after the cutoff deadline, which was end of October? Did any of the summer help do anything other than pick up soft yard waste?
Yes. Recycling and trash.
All right. And the full-time employees who requested the yard waste job and were not assigned to it, was there other work for them to do? Were they doing something else, or what were they doing? on those?
They stayed in their position, so if their position was in the street department, they stayed at the street department and did their daily assignments there.
Which would be like what?
Day to day, it changes every day.
Well, give me an example.
They could be driving a truck one day, they could be laboring one day, filling potholes.
Okay. All right, any other questions? Commissioner Shea?
Is there any grievance that we are going to hear relative to the employees working beyond October 31st, the seasonal help? There's no, I'm hearing that there are employees who were temporary, summer help, that did work beyond October 31st in tasks other than soft yard waste collection. Am I understanding that correctly?
Yes.
Yes, and so they did trash collection,
Yep.
other stuff.
That is the normal functions of a collections equipment operator, which was the temporary job assignment, yes.
And this is the summer help working beyond October 31st, when they really shouldn't be, but I imagine that's because we were short-staffed. I know that that's not relative to this grievance, I'm just interested to know.
Yes, I understand your point. They could. I'm not saying that they can't stay until the first week of December. It's how do we allow them to stay and deny our guys to go and do that job? That is where we have the issue. Not so much in what they were doing day to day or that they were here. If all of those guys had went, this grievance you would never have seen.
And so the grievance is relative to the 2 out of 10 that
Yes.
signed up for a specific shift that a temporary seasonal employee was otherwise assigned to.
Yes.
Okay.
All right, any other questions for Mr. McLean? All right, could we hear from the Solid Waste Department?
Thank you. Jeff LaFleur, Superintendent, Solid Waste. This grievance doesn't just affect the Solid Waste Department, it affects the whole division. As you heard, that we're borrowing help from every department. If we were to allow every person that signed up for it this past year, we would have depleted some departments where they would be crippled to do any work at all. That's where management rights has to be able to assign jobs and accept or deny, saying that we can take 7 people from wastewater. Let's say wastewater department signed 7 guys signed up and they wanted to come over here. The union side is saying that we would have to take all of them before I could keep my temps. Well, the wastewater department needs so many employees to operate correctly. We would borrow as many as possible for operational needs and then backfill with our summer help. That's basically what happened. We took all the candidates that applied for the position. We took what we could from each department without being detrimental or being hurtful with operations in each department, and then we backfilled with my summer help. We're looking out for the best interests of the city, doing it operationally that way. We've done this for years as far as denying people for them being needed in their jobs. I've had roll-off operators that were out and someone wanted to sign for yard waste season. I told them, no, they can't sign for yard waste season because they're needed in their position. The job needs to get done. That's the basis of this grievance, is that operational needs, we just can't deplete other departments.
Commissioner Lemon?
I have a question. So I'm thinking about this. So yard waste gets picked up Monday through Saturday?
Monday through Friday.
Monday through Friday. So this is during regular work hours?
Yes.
Okay, so, and is there, I'm assuming you would not get overtime if you worked at the sewer treatment plant and you went over to pick up yard waste? It would just be a hour-for-hour exchange? I'm just curious.
They would get the shift differential, whichever rate was higher, they would get paid so long as they met the 120 hours in their contract.
Okay. And so during yard waste season, how many extra people do you use?
To be honest with you, I'd keep as many soft yard waste trucks as possible out there. Some days we're picking up 100 tons of yard waste. So we would want as many employees as possible on every truck that we have. So I could have 20 people there. I could borrow 20 people. We just don't have the manpower to steal from every department for 20 employees.
Thank you.
Yes.
Commissioner Sherman.
So when individuals are signing up for these soft yard waste hours, they're not extra hours. These are, they sign up with the knowledge that they'll be taken out of their usual paid position and put in a different place. This isn't, I'm going to pick up some extra hours after my shift.
Correct to some extent. There's opportunities, if there is overtime, those employees that are temporarily assigned to my department would get it before anyone else in the division. So theoretically, they're working their 8-hour shift, but they also get the opportunity, if there is overtime, to sign, to say, yes, I'll stay, before everybody else in the division.
Okay, so when they're signing up, they know that this is, I might be assigned this position if I can be spared from my regular position.
Exactly.
Okay.
So Mayor, I guess why would an employee leave their regular job to do soft yard waste? Is it easier, or is that why? Or why would they do it?
No.
Not more money, right?
Oh, well, it is for some employees. Some employees would get another $1 or $2 an hour because it's a higher rate of pay and the opportunity of getting an overtime shift. That, it is a benefit for them to sign to come over, but, again, we have to manage the departments to say, to keep our operations running.
And Superintendent, in this instance, do you recall how many were on the list? I know Mr. McLean said about 10.
I think he's correct around that time. I don't keep them during the year. It's just a record
And
that I
you
don't.
used
But I do want to make one point that,
Sure.
that this whole wording in the contract came about where there's been years that I don't get anyone to sign for help, that nobody wants to sign. So, there's been 4 or 5 years that I've asked for this, from October to December. Nobody in any of the division would sign. So then I'd be mandating 6 guys that have to come up, or 8 guys, or 10 guys. Again, depending on what we need to operationally run the division, and I'd be out of luck. So this came about saying, listen, at least I have some safety that I will have some employees. I started off the year with 7 temps this year. I'm down to 3 right now, so I'm going to have to backfill or use whatever I can get. I have the sign-up sheet right now. Who knows how many are going to sign for this? We just don't know. And I have to collect yard waste. It's a service to the city.
Right. I mean, once again, the wording could be much better in this contract, because it should say something that if, the employees you can spare from your regular duties. I mean, I was under the impression that you were using the temp workers when there was people who were sitting at home and wanting to work. So I didn't understand the way this is written. It's very confusing, but these are already people working and they wanted to do the soft yard work. Okay.
And again, if 30 people applied for yard waste season, we couldn't deplete a whole division or whole department. Parks Department still has all their fall cleanup that they have to do. If I took 6 guys from their department would shut down. They wouldn't have enough to do all their work that has to be done.
Commissioner Shea.
And so do I understand correctly that if we were to pour over people's hours and the shifts that are relative to the grievance that people were not signed on for, we would find that all of the employees were working in their normal roles for these shifts that they are filing the grievance about? So, maybe I could have worded that a little better. So do I understand correctly that every instance of an employee being declined to work a shift, they were already scheduled to work their regular role and could not be pulled away from that without being a detriment to the function of their relative area?
Exactly. We, when we do take a list of employees, we do it by seniority. I take by divisional seniority and go right down the list and take the senior guys that wanted it first. So unfortunately, it's the lower senior people that get bumped off that don't get to come over. They're needed in their positions.
Can
Attorney Bolton?
Yeah, Jeff, am I correct in understanding that there are temporary assignments throughout the year other than for soft yard waste?
Occasionally, the division does do that, yes, for
Right.
certain positions that need work, yes.
Right. And if someone who is essential in another area signs up, are they kept in the area where they're essential, or do they get the temporary assignment?
They're kept in their essential position.
And that's, as far as you know, that's been true throughout the division since time immemorial.
Yes, sir.
If I could, Andy Patrician, Assistant Director of Public Works. I've been with the city for quite a long time. I was denied late back in the 90s when I worked at Solid Waste as an equipment operator to go on yard waste. It was common practice. It's been common practice since I can remember that if people are needed in their essential jobs, then they are skipped over. We've skipped over mechanics before. We've skipped over welders before. That all signed up on the list and they were deemed needed in their job. And that's been common practice as long as I can remember. So.
All right, anyone else? Questions for anyone? Either the union or management? All right, is there a motion on this grievance 2152? Commissioner Shea.
I would motion to decline the grievance, or deny the grievance.
Discussion? Go ahead, please.
I would ask that in the next iteration of the contract, that, I understand the problem, and I appreciate that you can't be pulling employees out of their essential areas. That just doesn't make sense. And I would ask that that be further elaborated in the contract going into next year. I understand why the grievance would arise, but in terms of the language and in terms of the decision-making process, I'm in agreement with management. I just think that on this and the other previous issue that we heard, we need to further elucidate these kind of conflicts in the decision-making process. Thank you.
Anyone else? All right, the motion is to deny grievance 2152. All those in favor of the motion say aye.
Aye.
Opposed? Motion passes and the grievance is denied. Next, we're going to do grievance 2151. No, sorry.
22-9.
22.9.
22-9, I'm sorry, 22-9.
This is for Steve Pecoraro. Steve put in for a foreman's position at the wastewater treatment facility where he has worked for 16 years, but the city awarded the position to a 6-month tenured candidate that did not meet many of the qualifications or possess a New Hampshire wastewater treatment plant operator license for the job. I do also have Mr. Pecoraro here if you guys want to ask him any questions or let him speak as well.
And could you, sorry, I was looking at the contract. What was the
Yeah.
last sentence you said?
Did not meet many of the qualifications or possess a New Hampshire wastewater treatment plant operator license for the job.
All right. Questions of Mr. McLean? Commissioner Shea?
Is it Mr. Pecoraro?
Yes, Mr. Pecoraro.
So Mr. Pecoraro believes that he was the best candidate for the job. Management does not believe he was the best candidate for the job.
Yes, sir.
and Mr. Pecoraro is available to, I guess, make his argument for why that is the case?
Yeah, his,
If he'd be interested in doing that, I'd be glad to hear his thoughts.
yeah, Steve.
Stephen Pecoraro, wastewater treatment plant. I'm a collection system tech. I believe the real reason why I was denied the position is because a number of years ago, me and another gentleman that worked at the plant, we went to Concord to the Department of Environmental Services and laid out a list of grievances and issues with the plant in Nashua. And management found out, and I have been forever denied a promotion. Basically, that's what it is.
How long ago was this?
2014.
Commissioner Shea?
I appreciate that insight. In terms of why you are the best candidate over the one that was chosen, can you speak to that?
Well, like it was mentioned, the guy that was promoted, he doesn't have, well, he does now, but at the time, he did not have a New Hampshire wastewater operator's license. Excuse me. I have a grade 4, which is the highest you can get. I've had that for several years. I was a plant operator. I have a collections grade 4. I have a bachelor's degree. This other guy, as far as I know, he doesn't have a bachelor's degree. He's never worked in a wastewater plant. I've been there, I've been with the city, it'll be 20 years this January. I don't know what else I could say.
Did he have a certification from another state that's equivalent, or?
Nope. He came from Methuen, Mass, and I believe their collection system, or their collections people in wastewater, he worked with 2 other guys, and it was said that he was a foreman. I don't know if he was or not. I think he was just the more senior employee.
Anyone else questions? Commissioner Moriarty?
Just out of curiosity, I'm reading this, and it said there were 4 candidates initially, and then 2 went back for a second interview. Were you one of the 2?
No.
Okay.
I was denied a second interview. The other one that was offered a second interview, he recently resigned from the city. He had only been in wastewater for, I think, 3 or 4 years, and he had a grade 2. So I don't know.
It's not necessarily material to this. I think it really comes down to the argument over merits, given that the city's response, or the management response, was relative to that. But I'd be interested to know what the issues were raised with the state, and if they have been since addressed, and if your action there resulted in a solution to the problems.
Well, I have the letter that I gave to the state. It's a 5-page letter outlining numerous issues with the plant. They came down, maybe Lisa could probably speak to this because she was here. And the superintendent at the time, he resigned soon afterwards. I don't know exactly what the state did. Maybe somebody else, maybe Lisa or somebody else could speak to that.
So, at step 2, Mr. Pecoraro did tell me about that. I had no knowledge of that prior to that. It's no secret that the plant certainly had some issues, and we worked very hard to turn those around. some of you may know that, Commissioner Moriarty, you certainly know that, worked very hard to, so we are fully in compliance and things are running great. We've got lots of redundancy, and I mean, we certainly can speak to that another day, but, you know, there were a lot of things that needed to be upgraded at the plant at that time, and we've made a tremendous amount of progress. I did not know of Mr. Pecoraro's letter or his going to DES until he told me recently in step two meeting.
And the city was compelled to some extent on these issues by the state, or?
As a result of Mr. Pecoraro's letter?
Not necessarily as a result of his letter, but was the impetus for addressing the issues as a result of state action?
No,
No, it was internally addressed.
yes.
Okay.
I can provide the name of the person I talked to with DES. She's still employed there. I can give you her phone number if you'd like to talk to her.
If I may, one more question. So when raising these issues to the state, to what extent and what did it look like in terms of raising those issues internally, and what was the outcome of raising them internally before going to the state?
Well, I talked to, and many people talked to the superintendent, Mario Leclerc at the time, and he just wanted it hushed up, and he didn't respond. He continued to do what he was doing.
And these things have since been addressed, is that correct?
A lot of it has been.
And the rest is in process, presumably?
Yeah. I mean, I haven't been an operator in a number of years. I believe some of them would still have complaints about things that have been going on, but I won't address that any further here, anyway. Yep.
Thank you.
Welcome.
Commissioner Moriarty.
Yeah, just a couple of questions. In your grievance, you mentioned Article 11 and 3, and so just going to Article 3, which is non-discrimination. I was just wondering if you felt that you were discriminated against due to sex, race, color, national origin, religion, lawful political or employees, organization, affiliation, age, marital status, or non-disqualifying disability?
No,
Okay.
I was discriminated against because I blew the whistle, is what it was, so. I mean, of course, the management is going to deny knowing this. I've been told by at least one individual that it was disclosed that, or it was revealed to management that I was the one, or one of the guys. The other person I went with, his name is Oscar Wright. He's since deceased, so he couldn't come and speak to this, but I was told that I would never get a promotion by this person. Of course, this is hearsay. Of course, it will be denied. But if you look at my record, I have no disciplinary issues. I don't know.
Now, is there a provision of Article 11? So you've cited Article 3 and Article 11, I think. Maybe this is for Mr. McLean, I'm not sure. You cited Article 3 and Article 11. Which section of Article 11 do you think supports the grievance?
But I have a question. Maybe Attorney Bolton could answer this. Is it illegal for a whistleblower to be harassed, or not harassed, to be discriminated against?
Well, whether it is or isn't, that's not what's claimed in the grievance. Well, let me put it another way. The grievance is for violation of the contract, not for violation of some other law, which may or may not apply.
So 11B, the city may administer testing procedures to determine the qualifications of the applicants for the posted vacancy. I don't think they administered any testing procedures.
Oh, it was written tests,
Written test, okay.
given at least to the three of us that initially applied for the position.
Okay. But that was the only, that was the only. If a permanent job in the department is not abolished, the job shall,
Could you highlight what you're reading, please? What letter?
okay, so that would be little a, 11, small a.
Thank you.
Job shall within said 90 days be posted on the bulletin boards in the respective departments together with the title of the classification, discuss the duties involved, sorry, I don't have my glasses. Rate of pay, job, location, and shift. Yeah.
Sorry about that. All applicants shall then be considered on a basis of minimum qualifications, seniority, experience, and ability. If an applicant qualified by reason of such minimum qualifications, seniority, experience, and ability, the job will be filled within 30 days following the closing of the posting period. So basically, the qualifications and seniority, the union feels was not taking into.
Speak to that. That is for AFSCME positions. That is not for, this is a UAW position that we're speaking to. So what would apply to this would be Article 11A, Section E. The city agrees that members of the union may apply for any vacant or newly created supervisory or administrative position and will receive full consideration according to their qualifications. However, final selection of such persons shall be the sole prerogative of the city. That's what applies. This is a UAW position. This is not another AFSCME position, just to be clear.
Thank you, because this contract is totally confusing. It says nowhere in there, UAW.
Would you like me to step down for management side?
Pardon?
Would you like me to step down for management side of this?
Anybody got any other questions?
Well, just so, are we in agreement with that, what the director just said, that we're talking about Article 11E? The grievance said there was no violation of Article 3, which is discrimination as in the contract.
Yes, as it's outlined in the contract,
Right,
but
well, that's
yes, he has his feelings.
All right. Wastewater plant?
Thank you, Mayor. Dave Boucher, Wastewater Superintendent. Just for clarification, I started in 2018. I had no prior knowledge to anything that occurred with Mr. Pecoraro and the state. So none of that information was used in the decision-making. He did come to me and let me know after we had already chosen a candidate, so I had no prior knowledge. We did have 4 internal candidates. We did interview, we did test all, they all came with varying qualifications, like I mentioned in my response. We did choose the two best candidates we thought. We sent them to the director for our second interview, and one was chosen.
Commissioner Shea.
So I asked Mr. Pecoraro to make his case in terms of why he felt he was the best employee or candidate for the position. Can you speak to, so you put forward two candidates?
Correct.
Can you speak to why those two candidates were superior candidates over Mr. Pecoraro?
We did have testing, and the testing involved real scenarios in the wastewater field, different scenarios, and how you would respond as a manager. They responded better, these two other candidates, to all the test questions. They also did come with stronger backgrounds of management, and that's what we're looking for, a management position. So that's why we chose the other two.
And this was a foreman's job, right?
Correct.
And that's not within the ASME bargaining unit?
No, that's UAW.
Anyone? Is there a motion on grievance? Oops, does Mr. Bolton have something?
Well, I just maybe to reiterate what Lisa had to say, maybe a little different way, but the subsection E is essentially what this situation is. And what this binds the city to do in subsection E is to consider members of the bargaining unit for promotion to a supervisory position. I don't think there's any dispute that a foreman is a supervisory position. And the gentleman was considered. He was interviewed, he was given a test, he was considered. The salient point, though, is in the last sentence of subsection E, where it says, final selection of such persons shall be the sole prerogative of the city. It doesn't say the best candidate will get the job. It doesn't say the most senior candidate will get the job. It doesn't say current employees will always get the job. It says the final selection will be the sole prerogative of the city. The contract was followed. There's no violation of the contract.
All right, anyone else? Questions, comments? Is there a motion on grievance 22-9? Commissioner Moriarty.
Motion would be to deny the grievance.
Discussion from commissioners? Commissioner Shea.
I am in agreement with the motion to deny the grievance. It concerns me that Mr. Pecoraro would feel that his action, which was in the interest of the public good, would put him at a disadvantage so many years later. He may have had, especially during that early time, some experiences shortly after the event that have left him feeling that way. I want to express gratitude for Mr. Pecораro's efforts to advance the wastewater treatment and ensure that we are doing what we should be doing here in the city. I think that is commendable. So thank you for that. I don't see any instance within the contract, and I don't believe that an argument has been made that any parts of the contract were violated. I take Mr. Boucher at his word that he had no knowledge of that prior event and thus could not have possibly use that as part of his decision-making process. But if Mr. Pecoraro does feel that he has been retaliated against for that action, I would encourage you to pursue that outside of the contract grievance process. You know, in the event that some past treatment has left you feeling this way, despite the people who treated you that way no longer being with the city, you know, I feel for you, and I appreciate that. And if it is those past events that have led you to feel a bit leery, especially when being considered for promotions, and it's not necessarily something material that has left you feeling that way, you know, I'm sorry that you have had that trouble and have gone through that, because that's not a good feeling, I imagine. But I'll just circle back and say I really do appreciate that there are people in the city who are willing to step out and raise issues like you have, because these things are very important, so thank you for that.
All right. Any other discussion? The motion is to deny the grievance. All those in favor of the motion say aye.
Aye.
Opposed? Motion passes, and grievance 22-9 is denied. Now we move to grievance 22-10. And please introduce yourself, just
I'm
so.
John Lyons. I'm the Vice President
Okay.
of ASME. I have the two individuals that would have gotten paid for this in the audience. If you have any questions beyond what I present as well. I would just give a brief description on what it is and then go from there. On Friday, April 8th, the street department was called in to block the Mines Falls Bridge by Nashua South School. It was decided by Mrs. Photo to use concrete barricades in the grievance discussions that we've had before. To do this, per the Watchman's Agreement, which I have a copy here, if needed to look at, any damage in park / unsafe, the park department is to be called. When we were not called with the idea, we do not have the equipment to move the barricades. Our backhoe, which is the equipment that we have at our shop, obviously the street department has front-end loaders. The backhoe can lift over 6,000 pounds, and the barricades are roughly around 3,000 to 3,500. We have many barricades at the park department. We have a bunch that are around our yard, that are out back by the gardens. There's also a stash over near Spine Road, which is just outside of Mines Falls as well, that could have been used, and our personnel could have been used for that. Our backhoe, like I said, has lifted the barricades as well.
So just so we have the context, I'm not sure everybody knows all about this.
Yep.
So the bridge into Mine Falls was damaged.
Correct.
We think by possibly a vehicle was driven over it, not by city parks or anything like that, but somebody
It could,
else.
from age and everything else, and wear and tear on, I'm not denying, wear, tear, vehicles,
Whatever happened.
everything, environmental issues, yes.
It became unsafe.
It became unsafe, correct.
So then the decision was made to purchase at some considerable expense, a couple $100,000 as I recall, the temporary bridge, and that was installed, and the decision was made to block it with the barriers to make sure that if a vehicle did damage the first bridge, that wouldn't happen again.
It was, the barricades were put there to stop any more, the general public to cross over or to use that bridge.
use the old bridge? Or
Use the old bridge.
Use the old bridge, okay.
Correct.
All right.
It was to stop any general public, whether they're walking, biking, or whatever else, as a safety measure to make sure that they weren't going to go across.
I can just add to that. So Engineer Hudson received a report from a structural engineer that said that the bridge was deemed unsafe and that we should close it immediately.
So the idea.
It was a very huge safety concern and an emergency to close it.
So the idea was to keep people off the bridge so that no one would get injured.
Correct.
Right.
Which
Okay.
there's no argument on any of that.
Right. All right, any questions? Any questions by commissioners for Mr. Lyons?
I'm still not clear on the issue. I guess you're saying that it should have been done by park employees?
Correct.
And not by the streets?
Correct. So, I have, like I said, I have the copy of the Watchman's Agreement, because this was called in on overtime. So any issue, anything like a tree in a road, tree down in wires, facility security issues, pool safety issues, park irrigation problems, or, which is what this category is, damage in park / unsafe, they are to call the foreman at the park department, so the park department would call our employees in to handle it. The only ones that do not require a call are light issues or flag issues. It's put into a report and then handed to us the next day.
And the park employees have the equipment?
We have, like I said,
All of this, you could have done that without needing the street department?
Correct. Yes, ma'am.
So that document you have is the Division of Public Works Call Response Guide and Contract Information? Is that what we're referring to?
Correct.
Is Section 3?
Yes, ma'am.
Could you read Article 9, Section H, since I don't have that?
All right, we're reading Article 9, Section H.
Section H.
It's from the contract.
Overtime work which is scheduled in advance or which requires employees to be called in for unscheduled work shall be offered first on a rotating basis among all qualified employees by classification in the department of the division which normally performs the work. Except as modified in paragraph 1 below, if the overtime situation requires additional employees, then such overtime shall be offered to any qualified employee in the department, then to any qualified employee in the division, and then assigned to the qualified employee in the order of reverse seniority within the department. Yes.
Commissioner Shea.
Are the barriers that Parks has deployed for some purpose, or are they just there?
We have them there. The ones particularly at the park department were put there years ago with the idea of potentially if anybody was going to go into the gardens at some point. We have never had anybody, and we've had other things that have blocked that access point. The ones that are on Spine Road have never been used, along with there's a couple other ones at other locations that have not been used.
So the Spine Road ones are just staged there?
They're just sitting there.
Commissioner Shea.
You said something about flags and lights. Can you elaborate on what that means?
No, I was just going through everything that's listed on the call response log, that's all.
Is that like if a flag?
So if a
is
flag
damaged?
comes loose, or if it, one of the clips on the bottom breaks free and it's only held by the top cleat, then they'll put in a report, and like I said, then the next day, if it's a regular day, we would handle it. If it gets to the point where it's going to rip off, or if it gets ripped off or causes a safety issue, then we would get called in for that, because then it would be unsafe.
Commissioner Lemon.
In the article that you just wrote, that you just read to me, in emergency, in the case of emergency, it still goes to the division that it's.
It goes to the department that
Department.
normally performs the work.
Okay, thank you.
Mayor, if I...
Yes,
Okay,
Commissioner Moriarty.
Yeah, Mr. Lyons, so before the superintendent comes up, I just want your opinion on his response, okay? Because his response said, paraphrase, in addition, the park department does not perform the work of placing Jersey barriers and does not possess barriers or the equipment to move them. The park department does not have the barriers or the equipment required to close the bridge.
Right, which we have the equipment and we have the barriers. And we have moved barriers in different locations. The operator that is here helped move a barricade at one of our parks 2 months ago, roughly, that we were told to move the barricade. So,
Thank you.
yes.
What kind of precision, so it's a front-end loader, you're saying, could be used to move Jersey barriers?
I said that's what the street department used, correct?
That's what the street department used?
Yes.
And what would parks use?
We would use our backhoe.
And do you think that the precision of placement is comparable between those two pieces of equipment?
I don't have an issue with either. Like I said, the lift capacity, if it is 6,000 pounds, so lifting basically half the weight, you still have full maneuverability and function of the equipment.
You could place them close enough with that piece of
Yes.
equipment that a person would not be able to squeeze through?
Correct. Because normally you would put them down and then you can use the forks to slide them in that much closer.
Any other questions? Commissioner Shea?
So in the, I mean, an emergency response would not dictate one department over another, I can imagine. This is being argued as an emergency response on the part of management. It seems to me that both departments could be equally available for, or is somebody already on for streets? Is that, was somebody already on, or was somebody from streets called in?
No, because, like I said, the issue is that because it happened within a park. So anything that happens within a park, the park department itself is called. We go fix our own problems. The street department gets called for any problems with on the streets and the sidewalks of Nashua because that's their normal function. And obviously within the respectable departments of what they normally do.
I guess my question is there any difference in availability of the persons between departments on the basis of an emergency? So if somebody from Parks wouldn't be able to be there for 2
No, because we're all
hours-
working the same shifts.
Okay.
So we were actually, both departments were already home.
Okay.
And we all had to get called in order to deal with this.
The temporary bridge, it goes from Mine Falls across the canal to school department property,
It still
right?
goes to Mines Falls. We actually, if you know the area, roughly, I'd say at least 60, if not 100, probably over 100 feet before you hit a gate, which at that point, that gate blocks off Mines Falls from the school.
All right.
So the bridges that are in Mines Falls are strictly in Mines Falls on park, considered park areas.
Anyone else?
Does anybody have any questions for the individuals I brought, or just the verifications of anything?
Commissioner Shea?
Just the 3 hours mentioned, is that the minimum for a call?
That's the minimum for a call-in. That's the, so we set this up, the street department only brought in 2 individuals, an operator and another body to assist. So that's why this grievance only has 2 people, an operator and another body that would have assist. So we're going equal parts. So the 3-hour call-in for both, for the individuals, for 2 individuals.
Thank you.
Yeah.
All right, if there are no other questions for Mr. Lyons, then we will ask the street department or the division. I don't know who's going to respond.
I think the assistant director.
Yeah, I mean, if the employee's personally interested in speaking
Yeah,
further
come on
to
up.
the-
So
Oh, okay.
if you If you have something to add, then
If I could.
we'll hear that, and then we'll ask the department.
My name is Jim Mulvey. I'm the chapter chair for ASME. Years ago, the city used to have watchmen. Two, I believe there was two at the street department, two at the landfill. The city decided to get rid of the watchmen and came up with a plan for an on-call process. I was part of the negotiations for the on-call process. The street department has a phone that they give to one person. They carry it for a whole week. And if calls come in, it goes to that. That person is to go to this, the matrix that everybody's talking about. And that's how it was negotiated. And that's where it goes from that phone. That person calls and says, hey, I've got an emergency at the park over in Mine Falls. The bridge has collapsed. We need somebody to come into it. He's supposed to go to this, check it out, and who's going to be called. He will then call that department's foreman. That foreman will call in everything, people that are needed. That's how the process of this has come about, and that's how it was negotiated, and that's how we feel it should have gone.
All right.
You have a
Can
question
you
for me,
just
Lisa?
remain, just in case we have questions? But Ms. Photo, do you have
No,
a?
this never got to the Watchman's Agreement. This was something that I received the call. I believe that the public was in danger. Our residents were in danger. I was very concerned about that. And I immediately called Superintendent Ibarra from the street department, because the street department, when we talk about normally performing the work, the street department normally performs that work. If we needed Jersey barriers placed on Main Street, when we do road closures, when we do any of that, it would always the street department would be the ones that would do that work, that would place barriers. And they can also do it the most efficiently. Could Park and Rec have done it? Probably. They don't normally do that work. It would have taken them longer. There's no question. Street department is set up to do that. They know how to do that. And because this was an emergency situation, and because I was really concerned about somebody getting injured, that's why this came about. I also just want to mention that the UAW foreman also filed a grievance. They withdrew their grievance when they heard that this was an emergency situation and that there was a safety concern. So I just wanted to add that, just to explain to why it happened this way.
All right, any questions?
All set?
Anyone? All right, thank you very much. Now does Mr. Patricia want to speak on this?
Hi, Andy Patrician, Assistant Director. Just a couple of things the director said, a few of the things that I wanted to say, but, the superintendents in the city are here, after ASME leaves, and some things do come in. I think one instance was a paving problem. I can remember up on Broad Street where John Abera was still on the clock, and in a case like that, you don't go to the watchman list. He has the right to call who he needs and what he needs to get a job done after AFSCME leaves. That is our job. So I got the call from Engineer Hudson that the bridge needed to be closed immediately. In a case like that, we knew exactly what the problem was, so we took we went ahead and did what we had to. This wasn't a call coming in saying there was something wrong in a park where somebody had to go investigate. The investigation was already done by a structural engineer, so we knew what we had to do. Again, street department has the equipment to do this. We set Jersey barriers all the time for detours, events, and other things. We have the same equipment at the street department that Weaver Brothers has when they set the barriers on Main Street. And what it is, it's like a scissor thing. It goes on top, and then you can just swing it around. When you have a barrier on forks, it's not ideal for moving them, because you have to try to shimmy it off and slide it off. The precision to try to place a barrier with forks is not ideal. The equipment that the street department has is what we use for that stuff. So that is normally performed by street department. I don't know if Superintendent Ibarra has anything else to add.
Hello again. Short and sweet, I just wanted to add a safety value or safety factor into this equation. So John was right, the lifting capacity on that backhoe is about 6,300 pounds. Where he was off a little is the weight of the barriers that we use. They're 5,200 to 5,500, depending on the mix. So you'd be taxing that machine, and we hauled those over the road. The loader that we used that night has 18,000 pound lifting capacity. So there, for us, is a safety value in that.
What's the capacity?
18,000.
Any questions?
And I'm happy to answer any questions.
Commissioner Moriarty.
First of all, I'm happy that no one was hurt and the emergency was taken care of. But I'm curious, where in the contract does it say during an emergency, the city can supersede and act without following the contract? I mean, where is that in the contract? I don't know. Is there a clause in the contract that states the city has the right to not abide? Because it seems like, in my opinion, that there was a violation, that the parts, from testimony, Parks and Rec were qualified to do it, and they weren't called to do it. So I'm just wondering where in the contract, is there somewhere in the contract where it says, well, no, it was an emergency, which, clear it was, but so allowed you to supersede that. That's my only concern. I'm trying to follow the contract.
Yeah. Andy Patrician, Assistant Director. I think when he read the, I don't know what article it was, but on overtime, to who normally performs the work, Street Department normally performs that work. So when it comes to a case of overtime, since they normally perform putting out barriers and stuff like that, that would be considered their job. I don't know if that answers your question.
I'm having a little problem here. All afternoon, we've been really sticking to the contracts. We've been, and some of us have been more in sympathy with things than others, but this, to me, Parks has the people who brought the grievance have a really reasonable point of view. I am very appreciative that it was an emergency situation and that Director Photo was just looking for people's safety. But if this contract, the way it's written, if it doesn't work, then we need to change it. But right now, I don't see how this is not a correct grievance.
Attorney Bolden?
Thank you, Mayor. Again, and I think I agree with what has most recently been said, you have to follow the contract.
Mm-hmm.
You have to follow the contract. The provision of the contract that applies is in Article 9, Section H, and it says, overtime work which is scheduled in advance or which requires employees to be called in for unscheduled work shall be offered first on a rotating basis among all qualified employees by classification in the department of the division which normally performs the work. It doesn't say if it's in a park, it has to be the park department. It doesn't say anything else other than the department which normally performs the work. The only thing I've heard is the park department may have been capable of utilizing their equipment somehow and managing to get it done. But the department that normally performs the work of moving and placing Jersey barriers is the street department. And that's what this work was. Moving, bringing the barriers from one location to the location where they were needed, and then setting them in the appropriate place to perform the function of blocking off access to this bridge. It seems to me that what we've heard, the only testimony that we've heard, is that it's the street department which normally performs the work.
Commissioner Schoeneman?
It seems to me that the call should have gone to Mr. Conan after Mr. Patrician as the head of Parks and Rec. I'd be interested to know if the superintendent of Parks and Rec has any agreement with the grievance or agreement that this should have been sent to streets right away. I mean, if their emergency was in streets, they wouldn't call in parks. But if the emergency is in parks, it seems like you would go to parks first, at least to the superintendent, because it's his jurisdiction. I apologize for putting Mr. Conant in the hot seat, but I would like to know.
Good afternoon. Brian Conant, Superintendent of Parks and Recreation. Commissioner, to answer your question, I think based on the emergency that I think was, that took place, I would consider it that people were at risk. It's a hazardous situation. I think we needed to, as a division, we needed to act as quickly as possible. So no, I think the assistant director made the right call he handled it as quickly as possibly, it could have been handled. So I agree with what transpired.
Commissioner Shea.
Did you have a follow-up? So regarding 9H, I am in agreement with the idea that the streets department normally performs this work. It sounds like parks far and few between, maybe every couple of years, is moving Jersey barriers for one reason or another. Or do you guys, are you moving Jersey barriers every now and again? How often does that happen?
I've been here since this past February. I honestly, in an honest recollection, I don't believe we moved any in the time I've been here.
And so for me, I'm in agreement on the issue of who normally performs the work, being the street department. In terms of area of domain, but I understand raising the issue of going to parks on this, but I don't understand how that might relate to the contract and what section that might relate to. Is there a space in the contract where you feel like that is the case? I know that there's like this pecking order manual, but is that referred to in the contract? Can somebody speak to that? I could see where, if that is somewhere in writing, that could be the basis for the grievance, but I don't see that the case has been made for that. So I don't know who would answer to that, or maybe there is no answer to that. Maybe there is nothing in this contract relative to going to parks specifically. The section seems to be who performs the work. I've not seen something that is relative to areas of the various departments being very cut and dry. Can anybody speak to that? I guess it's the onus is on the employees to make that argument, if it can be made.
Well, if I may, Mayor, it's very important for us in the best interest of the taxpayers of the city to work together, all departments. It doesn't bode well to say, it's public works work. We are very sensitive to providing the overtime opportunities to those who normally perform the work, because if we don't, that's a grievance. Honestly, I think the street department would have a grievance had Park and Rec done this work, because street department is the one who normally performs the work and who normally puts out Jersey barriers. I think that it really rests on that there's whoever normally performs the work, and that would have been the street department, and that's who did the work. It shouldn't matter whether it's in a park. It shouldn't matter if, where it is. What should matter is who normally performs the work, and because whoever normally performs the work can also do it more efficiently. And so I think we follow the contract in this case. And we've had several grievances on that very issue of who normally performs the work.
Commissioner Shea.
Just to kind of wrap my head around something that might be parallel. when we do paving of pathways in Mine Falls, do we contract that out? Is that done by the city? Who puts down the asphalt when we pave a walkway in Mine Falls?
I don't know that we've ever.
Not since I've been here.
Well, I have a
Do you know
similar
that?
question, which is, we did a ton of work in Lincoln Park.
Mhm.
Fixed the playground, ball fields, hundreds of thousands of dollars. A lot of in-house work. Who, was it streets or parks that did that?
Johnny Barra, Superintendent, Street Department. We do a lot of Brian's work. Feels good to say that, actually. But no, we assist as a division. I haven't paved in Mines Falls, but we have paved in other parks. So Street Department would perform that work because we do it all the time.
And in Lincoln Park, who did the work there?
Street Department.
I'd be interested to hear Mr. McLean.
Please, for a moment. As Mr. Patrician just said a minute ago, when this was called out, as the operator that came in to perform this function, there was a watchman from the street department that was called in, as that's who I reported to and got the phone call from. So we followed the watchman's agreement, even though Mr. Patrician just stated that we did not. Mr. Patrician also stated that we have the clevis to lift up the Jersey barriers. That was not used. We used forks to drive them out into the, so I just don't want you misled in that. That's not how it went down. As I was the one, like I said, I was the operator called in to perform the job from the street department.
And your department normally performs this work?
Street department puts down Jersey barriers in the streets, correct. So had Parks Department been called to put Jersey barriers in the streets department would have an issue. But I would have been very unlikely to see a street department grievance come across for something that was performed in the parks.
Is there any other situation where barriers have been placed in parks?
There are barriers placed in parks across the city. I know.
Another reference, which your question is, one that would kind of tie in to what you were stating was the Eaton Street Bridge. That was closed down. They had us put up fencing to block that off, to stop the general public from going through.
Did you use barriers in that situation?
Barriers were brought in later, only because the general public actually were cutting through the fence and climbing over the fence to continue on their pathway. Barriers were brought in, fencing was reinstalled, but again, people at their own will were still going through that location.
And who placed those barriers?
The street department did.
Thank you.
But again, we were called first to actually block off that bridge.
Yes.
All right, so to me, this whole argument seems to be based on two things. One is who normally performs the work, and then this Division of Public Works Call Response Guide and Contract Information, Section 3. So I'm very happy that nobody got hurt, that appropriate action was taken, but we are arguing over 3 hours of missed pay.
For two individuals, so 6 hours total.
6
yes.
hours of missed pay. And so you were saying that if the street department hadn't gotten called, they would have filed a grievance, and I think this is a totally appropriate grievance. So if we are going to follow, if we are not going to follow this call response guide, or we're going to have different rules for certain things in the response guide, I think the response guide should be changed so that employees are not led to believe that if an opportunity for overtime in the parks comes up, they will not be the first called. And I understand all the concerns about the Jersey barriers and things, but if we have this document and it's everybody's responsibility to follow it, then we should follow it.
And where is the reference to that?
In my packet, it's it's the handwritten thing right after the grievance 22-9.
I guess I make
So
one.
can I- yeah,
Go ahead.
No, I was just going to say, so that really is for call-ins that are coming from the general public or the police or something, not something that we're handling directly. So something that would need to be investigated. So if there was something, a sinkhole, or there was something in a park, although I think street department actually fixed a sinkhole in a park once. But if there was something that needed to be investigated, then the park department would get that call and then take the appropriate action. It would be the foreman, the UAW foreman, not ASME in that case. But this wasn't that. This was something that came directly to our attention whereby management actually, was aware and we knew what the situation was and then needed to respond. So it's a little bit different than the actual call-in.
I think
The
we are
watchman's
dealing with
agreement they're
more than
talking
just this situation in the sense that, okay, if barriers need to be in parks again, if the board rules that that's Parks Department work, then the street department can't ever put barriers in a park. Can they?
No.
No, that's not necessarily the case.
Because how is that not Parks Department work? If
Correct.
barriers in parks are Parks Department, then whenever a barrier is needed in the Parks Department, you've created a grievance if you call the street department. Right?
Mr. Mayor?
Yes, I mean, this has value in terms of the future. This has implications for the future as well.
Yeah, and that's, if you wouldn't mind, Dan Hudson, City Engineer, that's why I rose to spoke, because this was a safety issue, a critical safety issue, and a timing issue. And when I went to Mr. Patrician with the issue, I am thankful that he responded with, what could be done most immediately and with the best tools, basically, to accomplish the task at hand. I hope that if we have another situation like this, we're not going to delay things by trying to review who can possibly do this with some piece of equipment they have. The urgency of this was critical, and it was responded to quickly in a professional manner by people that routinely do the work. And so that's what I would hope. That's why I'm glad we did, and I would hope we would do every time in a future situation like that. Thank you.
Commissioner Schoeneman.
I guess what I can't fix in my mind is when the question says the division which normally performs the work, is it the work, Parks does the work in parks, or Streets always does the work of Jersey barriers? And that's what we're trying to decide, and we are setting a precedent. And I think it's a very, very hard question at this point, and we have to just decide one way or the other.
Well, so Parks doesn't always do all the work in a park. In fact, we're working at Atherton Park right now. Street Department's doing the majority of that work right now. So, it's not that Parks always does all of the work in parks, certainly. It's a team effort. And honestly, that's how we've saved the city a tremendous amount of money, by working together on some of these projects. If we subcontracted all of that out, it would be very costly. So whenever possible, other departments come in and help each other so that we can leverage our resources and get these projects done more efficiently and more cost effectively. And Atherton is a good example. Lincoln Park, Mayor, that you mentioned, it is another. So it's very common. We always work together. The street department often works in parks.
I have a question. So are you telling me that it is never appropriate, or if we let the park department put a Jersey barrier down somewhere in a park by themselves, that is somehow going to set a precedent for all time? Or that never happens? Okay.
I don't know that that's ever happened. I can't think of any time when the Parks Department, but certainly, no, there would not be nothing that would preclude the Park Department from doing something like that
But
at
the
some point in
opposite
time.
argument seems to be that if we say that this grievance is justified, that we're setting a very dangerous precedent for the opposite, which I think is, personally to me, it's very confusing. It's like you can't have it both ways. If it's going to be that, letting the street department do this and, says one thing, but if we have the Parks Department do it, that's a problem. I mean, what if there were the opposite situation? Say that something happened on the streets, they go to call the street department, nobody is there, the Park Department superintendent is there, and he does something that the streets department normally do. So would that be like, so now they get to do that all the time?
Well, it would depend what that was. So there's no grievance regarding a Park Department employee moving a Jersey barrier. If there were, my response would be the same. If it were in a park, now the street department could grieve that. I mean, they certainly, but we need to work together on these projects. That's really important. But when you're looking, it really boils down to who normally performs the work, and it is whether it's a safety issue, whether it's an emergency, they're all really important factors. But there have been times when we've done things and we've known that we might get a grievance, and we'll just pay the grievance because you know what, it's a safety issue, and that's more important right now than anything. In this particular case, though, the street department normally would perform that work. So that's really what this, I feel, boils down to, so.
Commissioner Shea.
For snow clearing on the sidewalks, what department generally does that?
That comes out of the street department, but they all participate.
Is there a Parks sidewalk cleaner that is used and a Parks employee in French Hill on Lock Street?
There could be, but all of the sidewalk clearing is either done by the parking department, which is downtown, or through the street department. So the street department will initiate that, but certainly there could be park employees that are in those sidewalk tractors, absolutely.
Okay. I just recall, talking about the safety of French Hill, and the initial response was that the streets department did not have a piece of equipment that was adequate to clear those sidewalks with obstructions.
Right.
And on, kind of further sussing out the issue, there happened to be a piece of equipment that was under the Parks Department that had a foot less of clearance. Instead of 4 feet, it was 3 feet wide. And the initial resistance to using that equipment for a thing that's outside of the parks delayed addressing a safety issue. And for me, I very much appreciate the point of using all of the resources to the best of our ability and addressing safety problems. I don't know that precedent matters in terms of what the crux of our decision is here. I don't know, I don't think that precedent matters. I think what we're here to talk about today is the contract and the language of it. And I don't see that an argument has been made that there's been any violation of the contract, and I think, on the contrary, a good argument has been made regarding who normally performs the work. So, I appreciate that the Parks Department has come, or individuals from the Parks Department have come here to raise this issue so we could talk about it. But I just don't know that a good argument has been made on behalf of the grievance, and I would not be supporting it.
Yeah, I would just say, in each grievance so far, we found issue with the contract that could be improved upon if both parties agreed. And here again, when they the parties negotiate again. To have an emergency clause would be a nice thing to have in the contract. That being said, we've heard testimony from the city that the street department normally performs the work. And so if that is the case, then there is no violation of this contract.
I would just generally commenting on the ambiguities in the contract.
Right.
These are old contracts. I mean, these things go way back. And the problem, the difficulty for both sides negotiations are usually about wages and benefits and a few critical issues for each side. So in these situations throughout the contract where there's ambiguity, if the city says, well, I'd like to straighten out the ambiguity in the city's direction, then the union says, okay, what are you going to give me in order to get that clarification? On the other hand, if the union says they want it resolved in their direction, then the city says, okay, well, what are you going to give up to get that clarification? So in the end, both sides kind of leave the ambiguity because it's not that important. They're talking about other issues that are far pay, benefits, the snow plan, on-call, call time or on-call time, other things that are far more significant. And that's why often these legacy contracts, are going to call it that, don't, have a lot of things in them that's very antiquated and in the end, don't get straightened out ever or for a long time. So I just am sort of trying to defend the city and the union for allowing these, some of these ambiguities or imperfect language to continue on year after year. All right. Well, we've discussed this one for a while. Does anybody have anything else to say on either side from labor management? And what about the commission? You have any other points or questions or anything? Okay, is there a motion on this? Commissioner Shea.
I would make a motion to deny the grievance.
Motion is to deny the grievance. 22-14.
10.
Sorry, 10. Sorry, I've already turned on to the next one. 22-10. Any discussion by commissioners on the motion? All those in favor of the motion say aye.
Aye. Aye.
Opposed?
Nay.
Motion passes and grievance 2210 is denied. We'll now go on to grievance 2214. Who's coming forward? Mr. Lyons?
Sorry, you get to deal with me again. Hopefully this one will be a lot quicker, as you stated. 2214, this was a tree on Artillery Lane. On May 18th, the tree on Artillery Lane was trimmed by a contractor. This is a job that Park and Recreation normally performs. We have roughly $1 million in tree equipment. We have 2 bucket trucks, 3 chippers, and at the time, 2 chip trucks, and we have multiple chainsaws that could have done the work. The tree only needed to be trimmed and to have dead wood removed, something that any of the maintenance men that we have could have handled, something that you wouldn't have to have needed a certified arborist for. If being a critical situation, we could have done the tree that day, we have the equipment and the ability to have done the job.
All right, Commissioner Shea.
And what is the, how would you define being made whole?
Basically to stop bringing in the contractors to,
Do any tree
for, we bring in, and I will differentiate, we do bring in contractors for specialty work, whatever else, where they need a crane or other equipment that we do not normally hold. Or if in the worst-case scenario if they are not able to get someone to perform the job. But normally, our department does all tree work. From there, it spreads out, so if we don't get enough people in our department, we go ahead and call through the different departments to get employees to do everything.
Commissioner Lemon?
Was this the tree on Artillery Lane where the woman was so vocal on social media?
Yes, ma'am.
So what do what do you think should occur? I mean, can the department decide that for whatever reason, a licensed arborist should be used in a situation? And if so, can they call, and there's none on the city payroll, I don't think, so can they call in a outside firm to provide an arborist if it seems to the department that that's
the city in the
advisable?
past, if my recollection is correct, we have brought in an arborist to inspect and to look at a tree. But then if any work was to be, that was done, they actually pointed out what needed to be done and our department did the work. It has only been done maybe twice in the 24 years that I've been working with the city.
Commissioner Lemon?
So why did it need to be a certified arborist?
I believe that was the city's decision to quell the person complaining on the situation.
Thank you.
Commissioner Shea?
I could fathom where the city might also enlist an arborist for this task to prevent potential litigation and action against the city should something happen with this tree in the future, given the sentiment of the person who raised the issue and the extent to which they felt strongly about it. So the arborist side, I appreciate that, and I think that that was absolutely the right thing to do. In terms of the tree work, you know, it sounds perhaps, and I'd be interested to hear the argument to the contrary. You know, it sounds like perhaps that work could have been done at the direction of the arborist by city employees. That's what your argument is here.
If an arborist was needed, yes.
Yes.
But normally, like I said, we go to multiple locations.
Yeah.
Like I said, with the equipment that the city has provided my department alone for what we do, we've definitely advanced from when I first started. We had an old fire department bucket truck that maybe could do 40 feet. And now we've got a 65-foot and a 75-foot bucket truck that we are called upon to cut multiple trees.
And what was what was ultimately done with the tree?
It was
just trimmed, or what? Like
it was trimmed, and the dead wood was removed from that tree.
And was there a lot of the dead wood, or was it just
That they were there with a 1-ton or a 550 with a chipper. It's basically, literally the same equipment that we.
And the idea there was to prevent these dead limbs from falling and.
It was to remove any dead and
something?
any limbs that were problematic for the homeowners that were in that location.
Commissioner Shea?
What was the height of this tree?
The overall height, that tree is over 100 feet.
And the damage to the top of that tree, if I recall, is really wind burn on the uppermost limbs, kind of from the clearance of the winter air. This is my impression of the tree anyway. I thought way too much about this. But like, you've got all these buildings along Amherst Street, houses that shelter wind from coming through. And it seemed to me what that tree was up against is that once you get past the height of the adjacent house, you've got this winter wind coming through, and when you get very cold days with fast wind and a very low wind chill, you have trees that are affected where the wind hits them. Like you could have arborvitaes that the top half of the arborvitaes, because it's next to a fence, gets killed every winter, and then the bottom half is quite fine. It seemed to me on that tree, that's what happened, and the limbs that needed to be addressed were the uppermost limbs.
The only problem with that argument is the company that dealt with it, Northern Tree, showed up with a tree, to my belief, looking at it, was a 60 to a 65-foot bucket truck.
Do you know
And
that that was the case? Or
I have a
was-
picture of we have a picture in a truck. I did not bring it with me, but it was literally this, it's maybe a 65-foot, so that's why I'm saying, that's why there's an issue. I wouldn't have an issue if the tree company showed up with a crane or something that reached 100, 125 feet, because that is out of our spec. So since I know for a fact that what they brought was literally identical to what we have, that is the issue for the grievance, but then also bringing a contractor in to do it is also the other half of that issue. So like I said before, that we've had other issues with trees, tree company, Pioneer or some other companies are brought in, they have a crane or whatever else, in which case is beyond our spec. So, but this was within our area.
So that's like, so they must have taken 40 feet off the top of that tree?
They
And if
didn't.
they had a 65?
They cleared lower branches
And they
off of
did-
that tree.
And they did not cut the top branches?
No, their bucket truck wouldn't even come close. Neither would ours.
That leaves me to wonder if we have adequately addressed the issue, because it seemed like a lot of dead wood was way up at the top of that tree. But that's a separate issue.
All right, questions from the commissioners?
I just had a thought, Mr. Lyon, I'm looking at your remedy to have park department do all required work, tree work as required, but yet, every year, this board approves a contract for an outside contractor to cut and trim through Mines Falls Park, and I've never seen any,
You're talking about Glenn Cole. He's drives the tractor and has a special cutter, a, what's that called? Brush mower that goes ahead and grinds everything that's going through. He's actually working for us currently right now. We bought a tractor just a couple of years ago, knowing that he is going to be retiring. We bought something not as basically well as what he has, but what he has requires a lot more maintenance. So we have already bought something to assist with that.
very good. So you may be doing that in the
And
future.
one of my other coworkers was doing it today.
In Mine Falls, I don't know that this is terribly relevant, but along the road, there's a big tree down that's been cut.
What's the location?
Excuse me, not Mine Falls, Greeley. You go through Greeley, you walk from Concord Street up the hill, and on the right, there's a tree that has a diameter about that big that fell and has been sectioned to some extent.
Usually for most of the parks and everything else, as long as it's within 15 or 20 feet from the edge of the road or the normal walking path, we will leave that, depending on if it falls on its own. If we take it down, then usually we will remove it.
All right, this one's,
So there's multiple ones. If you take that same road, and on the left-hand side, there's multiple red oaks that have fallen as well.
This one's been cut into big sections. Anyway, okay, anybody else? Commissioner Schoeneman.
Is there any specific part of the contract that you feel has been violated?
It's mostly the idea that in most cases, it's becoming a norm that they're bringing in contractors to do our work. So to us, it's a violation that you're having that happen without allowing us the opportunity to do that work first. We do understand there are special circumstances where contractors are brought in, but like I said, where they're bringing the same stuff that we have, and we have the ability, that's where, at least where our argument is.
But is there a contract provision that you think prohibits the department from bringing in contractors?
If you constantly bring in contractors, then yes, because like I said, you're taking work away from your own people, from your own labor force.
Commissioner Shea.
I understand the sentiment. Can you point to a specific part of the contract, like a section in the contract that you would be referring to?
So it's in the recognition, Article 2, recognition. It would be the entirety of it. I can read it for you. In the Public Works Division, the Director, City Engineer, Deputy Engineer, Assistant Engineer, Secretary, the Clerk, Board of Public Works, the Superintendent's Foreman, Timekeeper, help, summer help, and other employees classified in supervisory or clerical job are excluded from this working agreement. Summer help working in the division outside of the solid waste, those persons are temporarily employed. Oh, no, I'm sorry. The very first section. The city hereby recognizes the union as the sole and exclusive representative of the regular full-time employees of the above division, subject, however, to the exclusion listed in paragraph A below. So then you would go into paragraph A below that, and you could read through there. So the very first line is, the city hereby recognizes as the sole exclusive representative for regular full-time employees. Wait. Yeah, so that's our bargaining unit work. So that's where the contract is being violated. That is our work to do tree work, and that was well within the scope of our work. So we should have been allowed to do our job.
Commissioner Shea.
So my interpretation of this is that the city is recognizing the union as the representative of the full-time employees. That would not be relative to contract work, right? I mean, this is about the union being the entity that represents employees and their interests. I don't know that it has to do with contractors or some matter of exclusivity. The exclusivity, in my interpretation of this, is the union being the representative of the employees.
Yeah, that's true. Forgive me, I think I have every contract I recognize memorized, and normally what is considered your preamble is in the recognition clause of others, so Mr. Lyons would be.
It is the intent and purpose of the parties here, though.
No, wait, what are you reading from, just so we can
Of the
follow?
preamble.
Okay, thank you.
It is the intent and purpose of the parties here, though, that the agreement will promote and improve industrial and economic relationships between the city and the union, and set forth herein the basic agreement covering the rates of pay, hours of work, and conditions of employment to be observed between the parties here, though. The city agrees to apply all terms and conditions of employment in a fair and consistent manner to all bargaining unit employees.
So it is your position that having contractors come in is being unfair to the employees of the city when they are capable of doing the work?
Yes, ma'am.
Commissioner Shea.
So I'm reading the preamble, and I am seeing that the purpose and the core of the meaning of the preamble is that it describes what this document is. And it says that the city's going to agree to apply the terms of the document and the conditions of employment that are laid out in it equally to all employees. I don't see how that section also is relevant to any idea of exclusivity on the part of the union employees. I do understand the sentiment. I understand the idea of fairness and what your feeling is on this. I'm just still not seeing something in the contract that outlines.
Well, like I said, like Alex read, was the recognition. The city hereby recognizes the union as a sole and exclusive representative of the regular full-time employee of the above division, subject to however, but basically, the union is the city's workforce. And that's what, basically what it breaks down to. And so, yes, we know that once in a while we'll have to bring someone in, but normally you're not bringing somebody in to do a job that you normally could or handle with your ability, is what trying to reiterate.
I know, I understand what you're saying, I just don't believe that these words mean what you're saying. The union is a group of employees that have gathered to agree to collectively represent their interests, and the city recognizes the union as the entity that will advocate for those interests, and that union includes all full-time employees, with exception to the management, right? And the temporary summer help. I understand what you're saying. I don't think that that is what this section or the preamble means. And I mean, I could be wrong in my interpretation of this, but I just don't see where it means what you are saying that it means, and feel that you, like, on a philosophical argument, I can understand where you're coming from. I just don't see where this language applies to that philosophical argument. And so what we're talking about is the contract, and I could be wrong. I could be way wrong. I could be wrong in the way that I'm reading this. But I just don't see where these sections are relevant to the union. I read this, I see the union is the exclusive representative of the employees. This does not, to me, mean that the union is the exclusive group of people doing the work. The union is the body that is representing the full-time employees.
I believe what this means is the union has the right to negotiate exclusively on behalf of the employees. So the city could not pick somebody out and say, well, you know, president of the union, we don't care. We're going to go over and negotiate with this other guy. Or separately negotiate a contract with an individual employee. We would not be allowed to do that.
Correct.
Because the union has exclusive right to represent all of the individuals and each group of employees within the bargaining unit.
Right, it's an agreement with the city, with the
And
workforce and management.
you can represent them on grievances, like now. I mean, we couldn't say, sorry, we don't want to hear from the union on this. You have the exclusive right to represent the employees when their interests are involved. You have the right to bring grievances, you have the right to negotiate. We cannot go around you in those respects. But I think that's the meaning, I believe that's the meaning of these paragraphs.
And if I may further, if the Parks guys wanted to have their own representative, the city would not be recognizing them, as we are recognizing you here today. Because we recognize the union, we wouldn't recognize a lawyer that was hired on the behalf of a certain subsect of full-time employees.
We would never do that unless somehow they got separately certified as a bargaining unit. Someone else tries to negotiate, forget it. We don't do, you know, this says we cannot entertain that at all. Or if an employee comes to us and says, well, I want a separate deal. You know, I want my own contract. We can't entertain that. And I think that's what, and in doing so, we would violate these provisions. That's what I think it means.
Mr. Mayor, if I may.
Yes.
Speaking to the preamble and looking what Commissioner Shea is looking for, the preamble outlines that this is the document of governance, but under RSA 273A, which we follow under public employees, the conditions, terms and conditions of employment are mandatory subjects of bargaining. So although the PDFs are not contained within the document of the contract, the PDFs themselves delineate that work is ours. When you look at a PDF for what John does, it's going to delineate that that's his work. So the preamble leads to, outside the document, the PDFs would say, that's our work.
And what's a PDF?
That's their job descriptions. Again, we're not arguing that in the instance where you thought they took off the top of the tree, that a contractor couldn't be brought in for that because, as John stated, that's out of the scope of what we are capable of doing. What we've mentioned time and time again over all of these grievances this afternoon was who's qualified to do the work, who has the qualifications. They clearly have the qualifications, yet the city went out and contracted for the work that they could easily have performed. And we just argued streets performing normal work, tree work is normally performed by. So I don't see how all of a sudden we argue with a case in one grievance and then we're forgetting about that argument when we reach a second grievance.
Yeah, two points of clarification.
Yes.
One being, on further review of management's response, my sentiment about the tops of the tree and the way that that tree should be cared for, is perhaps immaterial, because that has nothing to do with the argument that was put forward or the response that was put forward by management. In terms of forgetting, I don't know that the issue is forgetting so much as asking for the specific piece of the contract to be referred to relative to this grievance. So it's not that I'm forgetting all the other sections that we've touched on. I'm just not, thoroughly and intimately familiar with this document, and I'm looking for the union to identify the basis for the argument within the contract. And so you're saying that the section, what was it, section 9H, this is relative to overtime work? No, what's the section relative to the people that normally do the work?
Well, that's delineated in the overtime clause, but throughout the contract, there's different articles of the contract that talk about being qualified or minimally qualified to do the work. And that definitely applies in this instance as well. Again, if we were talking about, a 100-foot tree, they're not qualified or capable of doing that. But that wasn't it. And as John testified to or explained, forgive me, the equipment that they used was no different than the equipment the city already owns.
Can you refer to the article and section?
So in Article 7, wages, under Section D, it talks about employees being assigned to work in a higher classification and needing to accumulate 120 hours within a 24-month period to be considered eligible for that. As we discussed in the prior grievance, Article 9, overtime, letter H, talks about qualified employees by classification in the department of the division who normally performs the work. When we talk about Article 11, vacancies, promotions, and transfers, states all applicants shall then be considered on the basis of minimum qualifications, seniority, experience, and ability. So throughout the contract, there's differing articles that lead credence to what our argument is.
All right. We should hear from the department on this, but we could come back. But
I just had a comment.
Commissioner Moriarty.
I just had a comment. Folks, listen, we're the Board of Public Works. We want Public Works doing everything in the city. We want parks doing the trees. That's what we want. We're constantly in argument with the mayor because he has other people doing stuff that we should be doing. We want you, we're here to help you. Okay, so, but in this situation, now, my recollection is the woman was irate. She had arguments with various city employees. It was a hot issue. We're trying to deal with it as quickly as we can. It's my recollection. She wanted the thing cut down immediately. We had to get an arborist in there to say, okay, no, this is a beautiful old tree. We want to try and preserve it. a lot of things happen quick, so it just, you know.
But that's the
I don't
point.
think there's an issue.
To me, it dropped the ball, trying to rush ahead of yourself by bringing in, all right, well, we're just going to bring in this person to do everything versus us doing, at least doing our part or our portion of the job.
I mean, I wasn't there at the situation, but I don't know. The decisions are made. We're here, we want you doing the work, so don't, you know.
And I know management will say in their rebuttal of that we've got 3 to 6 months of backlog. In the past, we've been up to 2 years on backlog of trees. So 3 to 6 months is actually minimal on any backlog for us.
Listen, if we waited one more day, that lady would have put a fire to that tree. That's how hot she was. So I'm glad it was taken care of, and I'm sorry that you folks didn't do it.
All right, now,
It's going to be quick, Mr. Mayor. I feel I have to respond
All
to
right, go
Commissioner
ahead, go
Moriarty.
ahead.
Because the prior grievance, we talked about, we picked the best people based on emergency, and now we're placating a citizen, is what it was. We've listened to various people, both management and the union side, say, if it's an emergency, we grab the people that we need to do it and we do the job. So why didn't we grab the people from the Parks Department to take care of that tree? That's the bottom line.
Well, let's find out from the city.
all right, Mr. LeBlanc?
Thank you and good evening. I'll keep this short and sweet. We do not have a certified arborist in the city. As we've brought up, sorry, Matt LeBlanc, Operations Manager. As we brought up already, I mean, it was a very high-profile tree. It hit social media. We really felt like it was in our best interest to act on it as soon as possible, but it was a delicate tree. It's a very old tree, big tree. We didn't want to just make any decision and just, shoot from the hip. We wanted to, make sure we got it right because there was safety issues, as the resident said.
What kind of tree was it, anyway?
Silver maple.
I believe it was a large silver maple.
Yeah.
So with the concerns of the resident, going into this winter, we did have a backlog of tree work, upwards of 2 years. We did work together pretty well throughout the winter to knock that down. We got it down to 3 to 6 months. And, but coming into May, middle of May, I mean, that's a pretty busy season for our Parks Department. So everybody was working. They were working on fields and leaf pickup and getting, everything that they typically do in the fall done. Not to say that we don't do tree work also in the spring, summer, or fall, but, with this one tree, with the safety concerns that were brought up, we brought the arborist in to work with us to see kind of what course of action we should take. And it was at that time that we got the paperwork back from the arborist stating, selective, pruning and cutting. So we needed to get this work done under the supervision of this, the certified arborist. We did it during the normal work hours. We did it between the hours of like 8 and 2, I believe. That way we didn't have any obstruction from school children or anything crossing. So that's why we did what we did. Throughout the whole division, and the whole year, we use contractors, maybe not daily, but monthly, quarterly, however you want to look at it. With, snow plowing, we all work together with contractors. Throughout the year, we have other contractors that work with us to do some of the tree work, whether it's too big of a tree and we need to crane it out. For whatever reason, our traffic department, we do long striping. We work together with contractors throughout the year. So that's why when this came about, we decided to contact a certified arborist due to the nature of what actually came through. And it obviously hit us as a huge safety concern, so we wanted to act right away. And again, we didn't want to just make any decision, we wanted to make the right decision. Thank you.
Yeah, I got a couple things I'd like to say. Brian Conant, Superintendent of Parks and Recreation. Yes, the resident was adamant that this tree come down. Silver maple tree, probably about 120 years old, something like that. It was a late May. I could tell. I got a bachelor's degree from UMass Amherst, plant, soil, insect science. Took a lot of plant ID classes, arbor classes. Could tell the tree was healthy. The resident was very vocal. They wanted the tree down. I would have been all for that if it was hazardous. It wasn't. So we had a track assessment done from Northern Tree Service that said the tree was healthy. From there, to ensure that the health of the tree did not decline, okay, there was cuts made by a certified arborist. It wasn't supervised. The guy that was in the bucket was a certified arborist. So that means your cuts are going to be perfect, okay? Because if you prune a tree incorrectly, you will induce the decline of the health of the tree. And, that was a part of it. We could go back and forth on the equipment. I think that the equipment that they had was similar. So I just wanted to mention that, okay? So if there are any questions, I'd be happy to answer them.
Commissioner Lemon.
We have a lot of trees and park space in the city. Is there a reason why we do not have a certified arborist? Because it seems to me that might really help situations going forward.
I think that's a great idea and a great suggestion. I being here in February, I'm new. I do believe that Parks is understaffed, okay? I think that's part of the issue. Hopefully we can solve that going into the future.
So you would be in favor of hiring arborists? I mean, I've been in Nashville for a long time, and it seems to me that many of the biggest fights we have had in the city have been over trees. I mean, all of us in this room have seen some of those fights. So if you had had a certified arborist on staff who could have been in your guys' buckets, would you have gone that way?
Yes.
Okay, thank you.
I look at a lot of the tree work we do is hazardous tree removal, whether it's a tree that's fallen down, a tree that's blatantly dead. That's what we do. If we were to drive around the city, I could point out numerous trees that want to be pruned. In looking at this tree in late May, the leaves were just leafing out. I could tell, there was a lot of dead wood. It had never been pruned. We're talking about a 120-year-old tree. That was part of the issue. So,
Commissioner Shea.
I'll be brief on this because I don't know that it's germane, but I believe it's the Arbor Foundation has a set of standards that cities can adopt and qualify for a designation as Tree City USA. Are you familiar with that?
we are a tree city.
We are a tree city?
We are.
We already have that
Yes.
designation.
Yes, we do. The mayor signs it every year.
I did not know that. In any case, I also just want to say, as far as all the grievances that we've heard today, each of these grievances has had a good outline of there's a decent argument that could be made for what section it's relevant to. I don't feel that the union has made an argument for any specific section of this contract. I take the letters in response from management regarding the backlog of work, and I think that that's adequate. But I would just ask that a more concise argument be made on behalf of these employees and their grievances with a specific citation of a section and a clear, concise argument as to why it's a grievance and why it's in violation of specific language of the contract. Because, I'm spinning around in circles up here and took up a lot of time, and I'm going to stop now, but it would be much appreciated if more attention was given to that as grievances are presented. That's all.
Commissioner Schoeneman.
There's an old saying, when you're getting tree work done, that there are guys who know a lot about trees, and that there are guys who know a lot about saws, and that it's always wise to go with the people who know a lot about trees. And it sounds like that's what the superintendent and the director did in this case. It wasn't simply placating an individual. It was considering the health of this tree, the safety of the neighborhood, and taking the advice of a specialist who knew how to keep this tree healthy and the whole neighborhood safe, not just considering the actions of one person. I think it was entirely appropriate for the city to bring in a specialist.
Thank you, Commissioner.
All right. Does any of the commissioners have additional questions? Is there a motion on grievance 2214? Commissioner Moriarty?
Move to deny the grievance.
Motion is to deny. Any discussion by commissioners? All those in favor of the motion say aye.
Aye.
Opposed? Motion passes and grievance 2214 is denied. Now we'll move to grievance 2216, which I believe is the next in order.
Alex McLean, AFSCME Union President. I'd just like to skip right ahead to the next one for just 1 second and say that the union is going to remove that grievance. The employee is no longer with us. So we only have one more to hear.
All right, so you are dropping grievance 2221?
Yes, 2221 will be dropped.
All right. So we're going to take up 2216?
Yes, so we can move to 2216, and that will be the last one that we hear today.
All right, go ahead with your thoughts or your presentation.
So 2216, it cites the preamble in Article 12. On 6/10/22, Mr. DeLuca was assigned to asphalt curbing crew and to ride to the job with a coworker. He expressed his discomfort in riding with this person and asked his foreman to take his own city vehicle. That request was denied. Mr. DeLuca then rode and worked with that person for the entirety of the day. A written warning for insubordination was then given for performing these assigned tasks throughout the day. On 7/19/22, Director Photo agreed to reduce the written warning to a verbal and take away insubordination, as he did what was assigned of him on the morning of 6/10/22. Her response to the grievance on 8/4/22, backdated to 7/29/22, did not state she was removing insubordination, and that is the reason we are here today. He did what was asked of him. That is clearly not insubordination. Yes, ma'am.
Can you define what insubordination is?
Insubordination is the defiance of doing a task that you are required of by your upper management.
Just, may I, point of clarification. I did reduce Mr. DeLuca's written warning to a verbal, but I did not agree to take out the word insubordination. So just, if there was a misunderstanding,
There must have been, because
but I did not. The intent was not to remove.
Yeah, and that's why we're here today. It's insubordination is a very big word. It's a very that is definitely not something that anybody should be labeled unless they are in fact insubordinate. If our employee was defiant to what his tasks were for the day, then he would have been insubordinate, and I could support the write-up. But riding with the employee, doing what was asked of him for that day, I don't see how we leave that word insubordinate.
I think it might make sense to have the foreman who dealt, and the superintendent who dealt with the situation that day, maybe explain what happened and let the board decide.
Hello again, John Ibarra, Superintendent, Street Department. This is Brian Anise. He's one of my street foremen, and he's the individual that assigned Mr. DeLuca that morning and had the engagement that he had. I'll preface it with, it was a very disrespectful engagement. That also is in the definition of insubordination. Discipline is one of my least favorite things to do. I get no pleasure out of it. But when you have what occurred that morning between Mr. DeLuca and my foreman, I can't tolerate that kind of behavior within my working environment. It just makes for a negative vibe to go through the shop. Again, disrespectful, failure to comply. Every day, we delegate priorities for operations. He, as a foreman, goes out and assigns his crew. I'll let you speak from there, what happened.
So I went out to assign the guys. As I was speaking to Mr. DeLuca, I told him that he'd be riding with one of his employees. He said that he did not want to ride with his employee. He would take his own vehicle. I said that, we don't need that many vehicles out there. We're taking one vehicle. You're going to be riding with him. And he just continued to just look at his phone and not look at me as I gave him other directives. I also told him to help with the burn machine with the trailer, hooking it on the truck, which I did with a couple of the other guys. He did eventually get up. He did eventually get in the truck with that employee. I had gone and already talked to John about the situation, and ultimately I feel that he just didn't do what I was asking. It took me multiple times of talking to him while he ignored me, and the other guys were smirking and kind of like just shaking their head upon this, so that's how I feel.
And ultimately, he did not hook up the trailer with the crew as he was assigned. Yes, he goes back and says he did get in the truck and comply at that time, but by the time my foreman has to come to my office and tell me what's going on, it's already occurred, the insubordination. So it's written up as an after the fact, and I did bring Mr. DeLuca in and speak to him and just say it's unacceptable behavior. You just can't be like that during our course of our operation. And in justice and fairness to the taxpayers of the city, all employees shall be required to report to work on time, shall not leave the job early, shall be prompt in reporting to their duties, and shall faithfully perform their duties. I would say that was a delayed response. It took him 4 efforts or multiple efforts to get him engaged and going in the morning. And again, I don't enjoy doing this. I wish we didn't have to be here on this, but we are, and I don't want to see this going forward. We went to step 2 so he could plead his case to the director, and she agreed, given the environment and the occurrence, that she would reduce it to a verbal warning from a written. And now here we are.
Commissioner Shea.
Go ahead.
Has the employee improved his behavior and responsiveness since that time?
He has.
That's good to know. Thank you.
Commissioner Lemon.
I'm a little bit confused, because you said it was reduced to a verbal warning?
Yes.
So if it was reduced to a verbal warning, then the way the city works, that written stuff doesn't get taken out, or you get written up as having a verbal warning?
It's still insubordination, but at a verbal warning level. So we have progressive discipline.
Okay.
Right, given what occurred, I started at an elevated, and then the director saw fit to reduce it to a verbal.
So I think what you're asking is, it is documented in writing that it was a verbal warning, right?
It's
Yeah, so there is a documentation.
It is documentation.
So there's a piece of paper, but it's the first step of discipline, which is verbal.
I
The
think.
next step would be written, which would also be documented, but now you're kind of stepped
Okay.
one level higher.
I'll ask the union to correct me if I'm wrong, but I think the issue here is not, I think that they would accept the verbal warning. What they want out of this is the insubordination, which I don't feel is appropriate. He was insubordinate, and that doesn't make somebody a bad employee. It's just he was having an off day, and, but, there's impacts to that, and it makes it really difficult for our staff to be able to do their jobs when people respond that way. And I think in this case, Mr. DeLuca was treated fairly by having the written warning reduced to a verbal.
When you have a verbal warning in your packet, what happens? If you're a good employee, I assume it never goes away.
It does, actually.
It does, okay.
Yep. So all documentation of written warnings and suspensions shall be removed from an employee's personal file after 3 years provided the employee has had no infraction of discipline within that period. All documentation of verbal warning shall be removed from an employee's personnel file after a 2-year period, provided the employee has had no infraction of discipline within that period.
And which provision, where are you reading from?
I am reading that out of Article 12, Section C.
I tell you, it goes back to this contract again. There's nothing in here that says insubordination, is there? I mean, as
Management's
far as
rights.
disciplinary action?
As far as title or just cause, it'd be under management's rights.
Okay.
Well, I think even more particular, Article 12, Section B,
B?
in the last line, mentions specifically insubordination.
Oh, failure to, okay,
Got
that's
it.
right.
Thank you.
Thank you, Attorney Bowman.
And do we know why the employee refused to go with the other employee? Did he make?
During the grievance process at level 2 or step 2, he said that he didn't feel safe riding with that employee. And maybe that's why the director lowered it to a verbal. But again, the behavior had occurred. We carpool every day, they're professional drivers, and given the fuel costs, we try and take the least amount of vehicles that we can to get to the job. So you're gonna have to ride with somebody, and you may not like the person sometimes.
Mr. Ennis?
Yep.
It was my impression at step 2, the step 2 grievance, that was not mentioned to, safety was not mentioned to you?
Not in the morning, no.
No.
Yeah.
That was during the grievance process itself.
And again, it wouldn't make sense for the employee to drive his own car because he's under city time and
Liability.
liability,
You have
of
to be
course,
in a
work
city
comp,
vehicle.
right. So
Correct.
that wouldn't fly, I understand that.
Yep. We have to transport the tools to do the job.
Yeah.
Any other questions of either the union or the department? All right. Is there a motion on grievance 2216? Commissioner Schoeneman.
I move to deny this grievance.
Any discussion on the motion? Commissioner Shea.
I don't see anywhere within the contract, and I don't think an argument has been made. Again, this cites Article 12. I don't see anything, nor has anything specifically been raised regarding Article 12. And I don't understand why the preamble is listed as part of this grievance. And for that reason, I support not, I support denying the grievance. It seems that it's an issue of disagreement as to whether or not the employee should have been disciplined in the first place. And, I certainly don't think that we should be micromanaging the decisions of the management and the director in terms of employee discipline. And for those reasons, I'll support denying the grievance.
Discussion? All right, all those in favor of the motion say aye.
Aye.
Opposed? Motion is granted, and grievance 2216 is denied. And I think that's all the grievances. All right, thank you. All right, well, thank you for coming and presenting as you did. We now will move on to the remainder of the agenda. Next, we have the solid, thank you, Attorney Bolden.
Thank you.
We have the Solid Waste Department, item A, Commissioner Shea.
The motion is to approve change order 1 to the contract with Clearspan Fabric Structures of Glastonbury, Connecticut, in the amount of $33,871. Funding for this change order is through Department 168 Solid Waste Fund Bond Activity SW Equipment Coverage/Storage.
Mr. LaFleur?
Jeff LaFleur, sorry, Jeff LaFleur, Superintendent of Solid Waste. So as you know, I came before you for a contract to build to cover all our vehicles at the landfill. While going through the building permit plans, I found out that my building was too big, and if it was because of the size of the building, I would have had to put in sprinkler systems for whatever reason through the building permit. At that point, trying to put sprinkler systems in an outside building with the cold weather, they wouldn't work properly. The expense would have been crazy. I took it upon myself to look into doing 3 smaller buildings that the vehicles would all fit in. This change right here is actually adding 1 truss to each building. So now it's going to be 3 separate buildings, side by side, the correct distance apart for fire department, fire safety. I need these 3 trusses to build it so I can get all my vehicles underneath. That's basically the easy answer for it.
Any discussion, questions? All those in favor of the motion say aye.
Aye.
Opposed? Motion passes. Next, we have item B, Commissioner Schoeneman.
I move to approve a contract with Simplicity Equipment and Service of Westfield, Massachusetts, in the amount of $40,500. Funding for this is through the Department 168 Solid Waste, Fund Solid Waste, account classification 55 other contracted services.
Go ahead.
So this piece of equipment that we'd like to rent is the grinder that I spoke about a few months, 3-4 months ago, about trying to grind up our C&D. I went out to bid to try to ship some of our C&D off-site. No qualified people wanted it. Nobody wants our C&D. So seeing that the construction and demolition material that comes into our landfill takes up 20% more airspace than our MSW, we're going to look into trying to grind our C&D and get the pile down smaller so it'll compact tighter. This is for a 1-month rental. It's just a trial. We're going to try it for a month. We're going to see if I can get that whole pile ground down, see how we like it. The actual machine that we're looking at, renting is a $1 million machine. So right now, it doesn't make sense for us to buy one unless I can justify using it enough to gain our $1 million back on this machine. So again, I'm going to rent it. Right now, I have it set up for December 2nd through January 2nd. We're going to run it the amount of time that we can, to hopefully condense my whole C&D pile.
Is this grinder affected, like if there were a giant snowstorm or freezing rain, is this grinder supposed to operate in all kinds of weather?
Yes, this it's a big diesel engine that'll run and it'll grind up everything. It'll also separate out any metals that are in the grindings. So I don't know how much we'll get out of nails and stuff like that, but we'll get some metal out of it, which will go into our metal pile and to be shipped out. So we'll get some revenue off of it. But yeah, we could use this year-round, rain, snow, sleet. They use them out west, out in Minnesota and everything. So yes, this piece of equipment can run all the time.
Anyone else? All those in favor of the motion say aye.
Aye.
Opposed? Motion passes.
Thank you.
Thank you. Engineering Department. We have item A, Commissioner Moriarty.
Motion is to approve the sewer service permits and fees as submitted.
Any discussion? All those in favor of the motion say aye.
Aye.
Motion passes. We have item B, Commissioner Lemon.
Motion is to approve poll license petition number 21-1624.
All those in favor of the motion say aye.
Aye.
Motion passes. Item C, Commissioner Shea.
The motion is to approve the purchase of manhole and catch basin frames and grates from Concord Windwater Company of Concord, New Hampshire, in the amount of $316,125. Funding is through Department 164 Wastewater, Fund Wastewater Activity Sewer Structures.
Mr. Hudson.
Thank you, Mr. Mayor. So as part of our paving work, we replace broken structures or ones that don't meet our current standards. This contract is to purchase the materials. We then provide those materials to the paving contractor to install. That way we ensure consistency in materials. We did bid this materials bid out and received 2 bids, and the low bidder is Concord Windwater. I'd be happy to address any questions about that.
Anyone?
Is
Commissioner
this
Lemon.
many manhole and catch basin frames? I'm just curious as to how many you get for $316,000.
Yeah, it's a lot. I mean, they average $400 to $500 a piece. I mean, this is a big number, so it's still a large number. But we do keep quite a stockpile at our street department, so they're available in a timely fashion for our paving work.
All those in favor of the motion say aye.
Aye.
Opposed? Motion passes. We now have, on the next page, item D, Commissioner Schoeneman.
I move to consider the hardship request from Liberty Utilities to excavate to replace critical gas valves in Brook Village Road at the intersection with Spitbrook Road.
So this is a request from Liberty. You can see the attached letter to the request. They have a couple valves which they tried to exercise and they were frozen, so they're requesting replacement of these valves. They do exercise these valves yearly and before paving, which they did. But for whatever reason, they're currently not working, and they've asked us to bring this forward for review and approval so they can replace them due to the critical nature. There is not a Liberty Utilities representative here today. I did ask earlier today, and they I don't think knew that we weren't using Zoom, so they couldn't Zoom in. So childcare issues, whatever, they couldn't be here. So should the board want to table this till Liberty can be here to speak to this, I think that'd be appropriate. But if you find it uncomplicated, then certainly they'd be happy to move it forward as well. So, yes.
Commissioner Shea.
You might know the answer to this. Are these valves something that would be used in an emergency to shut off the gas to that section of town?
Yes, they would, if these valves can't be closed because they're stuck open, they would have to go to the next valve in the system, which would be further away. So, it would expand the area of the issue, so to speak, in terms of a shutdown. I would note that this was very, very recently paved, so kind of in the limit of a paving project. We do intend to continue and go forward, and we'll keep going back and repaving this issue because it'll be at the match to the extended project. So the city will be coming and doing paving in this area in the near future. It's most likely that rather than make a full repair, that we would incorporate it into our paving project and take a contribution from them. But regardless, they did want to bring this request forward. And again, should you want to table it, then so they could speak to it, then that's certainly your purview, and I would understand that.
Commissioner Moriarty.
So I was just wondering how it came to their attention. Was there an odor issue?
No, I believe they were just going out to do their yearly exercising of valves. I'm not aware of a particular issue which led them to this. I think they just went out as part of their routine yearly exercising of valves and found these to be frozen open. So they reached out to us, and it was only a few days before the deadline for this agenda, actually. So we kind of rushed to get this on the agenda, and unfortunately they missed the part that they would have to be in here in person, and they had conflicts this evening.
Commissioner Schoeneman.
So you said these were inspected before the paving of the road?
Yes, that's what they have indicated to us, and I believe that to be the case.
And there's no leak?
There's no leak, no.
Okay. And this road is brand spanking new.
Yes, as of July of last year. Yes,
Thank you.
you're welcome.
Commissioner Shea.
How far in is it from the area to be paved?
The paving that's been done in the area, we paved along Spitbrook Road, and that ends at Brook Village Road, and then Brook Village Road was paved, and that ends at Spitbrook Road. It's kind of right at that intersection. These are right in the intersection where the two roads come together. So the paving, like I said, in both cases was kind of at the limits of those paving projects, with Brook Village Road being the most recent one, and it just goes beyond. And in order to dig this up and make those replacements or repairs, I guess they're going to replace it, yeah. They will have to cut into that end or apron, basically, of the new pavement.
So it's maybe like under 100 feet or something?
Oh, definitely under 100 feet. They did include a graphic depiction on the thing, but I'm not seeing exactly how much in the new pavement is on this, but in each case, it's a 6x8 excavation to cut out and replace the existing valve.
So we could either, we could table it, that's an option, but we could either make them wait until the moratorium period is over, having these valves be frozen for 5 years, or we can allow them to address it, make a contribution to the paving fund, and it's not going to impact the long-term lifespan of this road, because we are going to be able to, because of the way it's situated, address it with fresh pavement.
Yeah, correct. I don't know exactly. Since they have these valves that they can't operate, I'm not sure what PUC regulations they're under. It's not the same as a leak, which is the 6-month or same calendar year requirement. But there may be other requirements that I'm not familiar with that they need to comply with on some sort of a time frame. But I don't know. They would have to answer those questions.
It sounds uncomplicated to me. Thank you.
Anyone else? All right. All those in favor of the motion say aye.
Aye.
Opposed?
Nay.
Motion passes. We now have, item E is simply an informational issue, informational item.
Yes.
Any discussion on that? All right, we'll go to the wastewater department, Mr. Boucher, but we have item A, Commissioner Moriarty.
Move to approve the user warrants as presented.
All those in favor of the motion say aye.
Aye.
Opposed? Motion passes. Item B, Commissioner Lemon.
Motion is to approve Amendment 2 to the contract with Wright Pierce for the final design plans and specifications for the dry well valve and pipe replacement project in an amount not to exceed $448,500. Funding for this contract will be through Department 169 Wastewater Fund, SRF loan, activity, wastewater, plant dry, well valve replacement.
All right. Mr. Boucher?
Dave Boucher, Wastewater Superintendent. This project consists of replacing 3 stories of 36-inch piping, along with the associated valves, just due to normal wear and tear. Biggest part of this project is bypassing 50 million gallons a day, potentially 50 million gallons a day when there's a storm event. Wright Pierce is the company that did the preliminary work, engineering design on it. They've completed that. They've also identified this project in our facility plan. So this particular motion brings us through the final design of this project and also covers the bidding process. They'll oversee that. I don't think any questions.
Anyone? All those in favor of the motion say aye.
Aye.
Opposed? Motion passes. Thank you very much.
Thank you.
Now we'll move on to the director's report.
Okay, on August 24th, Sunshine Paving installed a leaching catch basin, put this closer to me, on Seal Street and riprap on St. Joseph Drive to help manage stormwater runoff. This is Queensway Circle. We installed final wearing course pavement on August 17th.
It didn't change.
Oh, see, this is Diane's usually here. She's unfortunately sick, so.
No waters either.
This is why I don't do this myself. Multitasking. Okay.
You want me to come over?
No, it's okay, thank you. I'll try to manage it. I'm also tired from the last session, so. This is final paving on Harris Road, which was completed on September 8th. This is the Canal Street Bridge. This picture was taken on August 19th, soon after the concrete repairs on the Canal Street Bridge pier were completed. The repairs were necessary as this bridge has been on the New Hampshire DOT Red List Bridge due to substructure issues, which is concrete deterioration and erosion. The work involved dewatering, chipping away concrete in poor condition, and then replacing that concrete. And also a bridge barrier on the top of the bridge had been damaged by a vehicle impact and was replaced, and the next slide is a picture of that. There was a crash in July of 2021, so that repair was made. So we have been, the city engineer especially has been involved in the new Brian S. McCarthy Middle School. This is the construction that started. And also we have the access road, D'Antonio Drive, which will be a public street, has been installed with gravel, and as you can see, the building frame is taking shape. The Park and Rec has been very busy lining and mowing fields. We have 80 acres of athletic turf. And here on the left is Mine Falls, and on the right is Main Dunstable. We had a very successful Wheels and Wings. We had nearly 4,000 people attend. That event grows each year. We had, it was a great day for one, and we had trucks and race cars and electric cars and antique cars, helicopters, planes, all sorts of things. So we also invited 68 Hours to End Hunger to collect both food and cash donations, so to support their work. So very successful event. You may have noticed that we have a new live tree on Library Hill, and we had Morin's Landscaping did the installation, and they will be taking care of it, so hopefully it survives. We have such a hard time putting up a dead tree every year, so we're really hoping this time the superintendent is taking great care to try to make sure that we get through it. So we added nutrient soil, and we're watering it, and Morin's is really caring for it, so we're hopeful. Our fall plantings are I think almost completed. We have some, the superintendent will be planting some flowers, some actually, not pansies, but.
Impatiens?
No. So,
Chrysanthemums.
no, the flower that you plant in the spring, it's not a pansy, but it's what I told you, Mayor, do you remember?
You did? Tulip? I don't know.
No.
Probably petunias.
No, the hardy flower that will last. I'm very excited to see this. He didn't want to put mums in.
You told me, I don't remember this.
I did tell you, yeah, because I was a little afraid because we weren't putting in mums. But these plants will last until, it freezes in November sometime. So we're very excited. Those should be going in, I think, in the next week or so. And now it's
Director,
escaping me only because
I
I'm
just want
tired.
to tell you, a number of people have told me how impressed they were with how the city looked this summer.
That's
Flowers.
awesome.
They were like, are you putting something special in the water? And I'm like, I have no idea. But they like the flowers.
That's great. I'm glad to hear that. We're trying to improve every year or so, and the superintendent did a nice job this year. Our Biddy basketball signups have started. And of course, this is our most popular rec program. So we usually have about 1,500 kids that participate, and it's the biggest program in the state. So families can now sign up on Rec Desk for that. The street department removed all of the broken bollards you probably noticed on the rail trail, and those have been replaced. So that's a great improvement. And that's another example of us doing work that would cost a lot more if we subcontracted it out. So there's a lot of great things, despite what you heard, that are going on. throughout the city. Another example here is the Atherton Field renovations. The street department has been doing a tremendous amount of work there, screening materials and prepping the fields and putting in the parking lot. We also have plans for a playground. This is going to be a great improvement to this neighborhood. Residents are so happy to not have cars parked all along the streets. So I don't expect this will be done until spring, but nonetheless, we've been working diligently on that. It's just another example of the crews are installing some curbing around the monument and the new parking lot. This is, we cleaned up the Veterans Memorial Parkway. We're cutting brush away and we're picking up some trash along. We try to do that as much as we can. We've had a lot of overgrowth this year, so we're trying to get that trimmed back. This is, we're redoing the basketball court at Fields Grove. That was badly needed. So that's another project that the street department is doing in a park. The pump station upgrades are ongoing. This is a picture of Spalding on the left in Northgate. We have only a small amount of finished work left on the Spalding Street, and on the Northgate you can see where the new forms are up for the loading dock. So, and the loading dock is needed due to the fact that the pump station is raised, and the loading dock will be needed for the loading and unloading of equipment. This is the pump station upgrade at Blackstone. Some outside work has been completed, including louver installation, and inside new pumps have been installed, and a new control panel. This is the Santerre pump station. This is our laboratory staff performing some river sampling, which they do twice a year, as required by our EPA permit. The digester coating project is almost complete. This is wastewater employees are shown here replacing a belt on one of our 3 belt thickeners. These belts allow liquid to pass through while solids stay behind on the belt, which helps in the solid retrievals process. You may or may not have heard there was a fatality at the Keene wastewater treatment plant, and it was a reminder for all of us, even folks that have been doing this work for 20-plus years, that you can never be too safe. And so our risk department did some electrical training for our staff just as a refresher. This is our aeration basin cleaning. We do this annual, each tank gets taken down annually and cleaned. They're working on one of 4 of them right now. These tanks are about 30 feet deep and hold more than 1,500 diffusers, and they are all hand scrubbed by staff, so this is really labor-intensive work. Yeah. And I just want to mention that the mayor will be hosting a meet and greet at our wastewater treatment facility, which will include a tour on Thursday, October 6th, starting at 5:30. So there are a limited amount of spots, so we encourage residents to give us a call if they're interested in that. The mayor's going to tell us about all the great things happening within the city, right? And then the tour of the wastewater treatment facility as an added bonus.
Is there any age restriction on that?
No.
Our 3-year-old has a fascination with the sewers and where everything goes.
Oh, absolutely.
So
You
might love it.
Let us know. Yeah, that's great. You know who else has a fascination is Tim Cummings, our economic development director. His little guy is just absolutely fascinated with wastewater and sewer.
My sister became a sewage treatment plant operator because she was always fascinated by grates.
It is really very interesting.
Yeah.
It's a fun tour, yeah. Our next household hazardous waste collection will be held on Saturday, October 8th from 8 to noon at Crown Street. And the curbside collection of oversized items and appliances will be ending for this season. The last date to request a pickup will be Friday, October 21st, and collections will end Friday, October 28th. And this is just a picture of our recycling table at the Nashua Goes Back to School event. We try to get out there as much as we can to encourage residents to recycle. And I wanted to let you know that we have now an American flag drop box. So you can bring your used flags and put them in the box, and they will be disposed of properly.
Where is that?
So, that is right now at the landfill, which is near the entrance to the landfill, the solid waste office now. But it will be moved when when our new building opens. We'll be moving it to in front of our building. So.
Whose idea was that?
Actually, mine, sort of.
Good idea.
That's a really good idea.
Yeah.
It's a really good
Yeah.
idea. I mean, I've had questions. If you were raised as a Girl Scout like I was, when I see people like with their flags on the ground,
Yeah.
you know, and tattered, they should not be up when they
Right.
look that bad.
Right. So, and we had our new water truck was delivered in August, and this is replaces the old truck that had been in service since 1990. And the Floral Hills landfill will be closed on Indigenous Peoples' Day. So trash and curbside collections will be delayed a day that week. And that's it. Any questions?
All right, questions or commissioners' comments? Anybody have questions or comments?
I have one. I think.
Commissioner Lemon.
We should think about getting an arborist. I mean, I don't know what an arborist costs, I must say, but I really think, I have seen so many fights, and I saw all the social media about that tree. It would be great if we had a city arborist who could just, and we have, and we're a tree city, we have lots of trees. It would be a real service to people in the city.
I think, it wasn't Superintendent Cajano an arborist?
He was not a certified, he was tree warden, but he wasn't a certified arborist. I think we did have a certified arborist on staff, though, years ago, but he retired, and that position was never replaced. The superintendent alluded to the fact that Park and Rec is understaffed, and it is. So that's an issue, but yeah, I mean, I would be in favor of that, certainly Commissioner Lemon, as long as we could find the funding to
Yeah.
do it. That's always the issue, right?
Right. Yeah.
Commissioner Shea.
I just want to note that even though we did not approve or come to some middle ground on any of the grievances today, that I appreciate that we have an environment where these issues can be raised and we can talk about them in a civil fashion, and we can review the terms of the contract openly and publicly and explore the merits of the arguments. And I appreciate that the city employees feel comfortable doing that, because it's important that we have an open dialogue with our employees, and that they feel like they can raise an issue when they see an issue, and you know, whether it's perceived or actual in relation to the contract is you know, one thing, but the fact that we have this culture and that the union comes to represent employees, and we can work through the issues, I think it's really important, and I appreciate all the time that everyone here spent, including city employees, to explore those and come to a determination. So thank you to all the city employees, and thank you to my colleagues for taking the time this evening.
And one thing that you didn't see is there were many, 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 many more grievances that we worked through that didn't come here before you. So there's been a lot of time spent, and I don't think that this group represents the majority. In fact, I know they don't, so I would like to say that publicly. I think we have a really great group of people who are extremely reasonable and work really well together, and understand that our purpose for being here is to serve the taxpayers of this city, and that's our only reason for being here. You know, otherwise, we don't need to exist, and that's really important to remember, so.
Any other commissioners' comments? All right, we have personnel now. In the interest of time, we could consolidate 5 motions to accept resignations into one, to accept all 5. Or, no, it's 5 resignations and a non-public, I think.
Okay. There's
Um,
four retirements, I think, Mayor, and 1 resignation.
4 retirements and 1 resignation. Unless someone objects, that would be the motion. Commissioner Shea.
I would so move to approve motions A through E as written in our agenda.
To accept the retirement of Richard Chick, the retirement of Terrence Gilchrist, Kathleen Barabee, Eric Faulkner, and the resignation of Paul Pellerin. Any discussion on that motion? All those in favor of the motion say aye.
Aye.
Opposed? Motion passes. We now have a non-public session. Commissioner Moriarty.
I don't have it, but I can just.
I think you do. I think I gave it to you. It should be there.
Anyway, the motion.
Lisa, just a second. Okay, we're good.
All right. Commissioner Moriarty.
Yes, thank you, Mayor. I move by roll call to seal the minutes of the Board of Public Works Personnel Non-Public Meeting of August 25th, 2022, until such time as the majority of the board votes that the purpose of the confidentiality would no longer be served.
Could you call
Mayor
the roll,
Dodges?
please? Yes.
Commissioner
I vote
Moriarty?
Yes?
Commissioner Schoeneman?
Yes.
Commissioner Shea?
Yes.
Commissioner Lemon?
Yes.
Commissioner Moriarty.
Mayor, I move that we adjourn the meeting.
All right, all those in favor of the motion say aye.
Aye.
Opposed? And the meeting of the Board of Public Works of September 22nd, 2022 is adjourned at 6:49 PM.
I just.